My lord, in respect of the item number 1 to 4, I am for the respondent. My lord, my note is about to get over, my lord. Just finally, few hours I need. My lord, can I come back at 3, my lord, and submit the note?
See, we will not take up original said matters. We will permit you to file it during the course of the day with our officers.
Very well, my lord.
Yes, you.
Grateful.
Thank you.
May I just file the notes?
Yes, please, please. You do.
Lord, so far as items 1 and 2 are concerned, Lord, there are 234 and 236, my Lord. 36, my Lord, we have not filed notes because those had become infructuous, really because the final hearing had taken up. So, my Lord, these two notes are in the 234 applications, my Lord.
Fair. The written notes of arguments filed by the petitioner be kept on record, full stop. On the prayer of learned counsel for the respondent, the respondent is granted liberty to file its written notes of arguments during the course of the day. The matter is reserved for judgment.
Grateful.
We'll exchange the notes, my Lord.
Please do that, and you whenever you file it with your officers, যখন তোমাদের কাছে ফাইল করবে তুমি একটু এতে দিয়ে পাঠিয়ে দিও, তারপরেই পাঠিয়ে দিও।
সবাই মিলে আজকে নোটস এক্সচেঞ্জ कर लेंगे उस समय 115
Yes, Mr.
We are this side. I had just, my Lord, started just 5 minutes on the last day.
Yes, just
with
barely.
regard to the claim on account of increased electrical energy and extra expenditure for the diesel generators set. The basis was that this boiler was necessary for my captive power plant so that my dependence on the consumption from the DVC is reduced.
Yes.
And also, my Lord, I do not have to hire the diesel generator sets. So what here I am showing that, my Lord, when they supplied the boiler and it was found to be defective, I had to continue with consumption from DVC and also, my Lord, the diesel generator sets.
Yes.
So that is the extra expenditure, my Lord, which I have claiming.
Yes.
Because the supply did not conform to my requirement. And how I am showing that, my Lord, if I had got the boiler, my consumption from DVC would have been only the minimum contract demand. Here I have produced the bills of the DVC. I am showing what is the minimum contract demand as per the bill plus the per unit consumption, which is the total amount of the bill. So the total amount of the bill for these months minus the minimum contract demand is the additional expenditure on account of electricity consumption. And on actuals, I have shown the diesel generator set expenses every month, which have been corroborated from my ledger account.
All right.
And the two documents which I had marked exhibit are, my Lord, this is the chart I am showing your Lordship, my Lord, which has been referred to in the award. I'll just show that document once. This is exhibit 107. Marked as exhibit 107. In fact, I'll show it from the award and I'll refer to this document because the award refers to this document and exhibit. So, my Lord, let me come back to the award where this finding has been discussed. That is internal page 102.
Yes, 100.
The paragraph starts at the bottom of the page. There is a major claim made by the claimant in this proceeding.
Yes.
That is on account of increased cost of electrical energy and extra expenditure. This claim has been narrated in paragraph 48 of the statement of claim. Detailed evidence in support of such claims have been given by CW1 in para 55 and 56 of the affidavit of evidence. This claim, according to the claimant, has arisen by reason of the failure of the turbine to perform, which had prevented the claimant to utilize captive power plant till the new turbine was installed, which resulted in sufferance of loss and damage by the claimant. In order to prevent sufferance of high electricity and fuel charges, the instant contract was entered into to purchase the TG set. TG set, which was supplied by the respondent, ultimately did not perform. The claimant could not get the benefit of the said set and consequently went on incurring electrical energy for a higher amount. The schedule containing the details of the increased cost of electrical energy has been produced by the claimant, has been exhibited as 107, Exhibit 107. This is a chart supported by DVC bills. DVC bills are the primary document, and this is a schedule prepared on the basis of the DVC bills. The claimant had also produced the bills raised by DVC from whom the claimant used to get electrical energy, which are Exhibit 114. Calculating in details about the extra expenditure of high safety oil has been disclosed in the statement of claim marked as Exhibit 108. This is the diesel expense. The claimant has also referred to the document being the ledger showing the expenses incurred on such account being Exhibit 115. The claimant's case is that high expenditure on account of electrical energy could be reduced only after installation of the new machine after 8th June 2010 from 9.43 per kilowatt hour to 2.57 per kilowatt hour. This benefit I would have got earlier. The evidence in this regard of CW1 and CW2 was placed. And here also kindly note, it is CW1 who has marked these documents as exhibit. Because why I'm saying this? Because I'm told other side has shown certain questions of CW2, saying that he has said that I am not a commercial man, I am not in a position to explain those documents. My submission will be he was not required to explain those documents because I have brought these documents in cross-examination. If I failed, then a doubt would arise.
Who are you and who is he?
CW1 is the person in the commercial department who has exhibited those documents. He has proved and exhibited. So the relevant cross-examination would be of CW1 insofar as these 4 documents are concerned. It is evident from the record that no cross-examination was made by the respondent on this document. So these are these 4 documents. According to the claimant, that claim of damages on this account was directly a result of the failure of the respondent's turbine. Against this claim, the respondent's contention was that annexing DVC bills and the ledger account are meaningless, meaning Exhibit 107 and 108 are meaningless. The respondent's contention was that claimant had not proved the said claim of 7.56 CR. According to the respondent, there is no proof of payment to DVC as allegedly made by the claimant. According to the respondent, that the said claim of the claimant on account of increased cost of electrical energy is baseless. Considering the above contention and counter contention of the parties with regard to claim on account of increased cost of electrical energy, and after considering the documents relied upon and the evidence led in respect thereof, I come to the finding that since admittedly the machine did not run satisfactorily after erection from 28 December 2006, naturally the electricity could not be produced out of that, which was the main object of the claimant for entering into the said contract with the respondent. It is also to be considered that such electrical energy was required by the claimant not for distributing the same to other consumers, but for its own use in its plant at Durgapur. Therefore, such energy was a most important factor to make the unit of the claimant running continuously with minimum cost. The claimant, however, has not made any claim for damages for it not being able to run the plant and consequent damages there. It has claimed only the money which it had incurred to make its unit running by paying extra and or more expenditure to buy electricity from DVC and on account of diesel. I have already held above that the machine had failed to perform according to the contract. Accordingly, the claimant has become entitled to extinction of price. This part, my lord, I had dealt earlier, my lord. If that becomes the position in fact and law, then automatically the question would arise as to whether by reason of such non-performance of the machine supplied by the respondent, the claimant in addition to extinction of price would be entitled to any damages from the respondent. Here in the instant case, damages as claimed not in the nature of loss of profit, but on account of increasing extra expenditure for buying energy which the claimant could have avoided had the machine run effectively and in accordance with the parameters contained in the contract. The principle of restitution.
They have not actually claimed for damages as such. This is not damages. This is just the costs you had to incur.
Yes, cost which could have been avoided. It is one of the
Yes.
principle of restitution.
Restitution.
That is one of that is the nature of damage.
Not any further damages for
No,
profit
not any.
which you could have. You have
I
not
could
asked for that.
Not, I have not asked for that. I accordingly hold that the claimant would become entitled to claim the damages by way of increased cost of electrical energy as claimed in prayer D. In this connection, I may refer to the claimant's contention that the claimant could ascertain the extra cost which has incurred only after the installation of the new turbine on 8th January 2010. According to the claimant, such money could have been reduced from 9.43 to rupees 2.57. If I accept this figure given by the claimant, I must come to the conclusion that if the TG set which was supplied by the respondent could function properly in accordance with the contract, claimant could have incurred expenses on account of electrical energy at a reduced price.
So, Shen, what is this erection date being 28th of December 2006 and installation 8th of January 2010? Because previously it's mentioned the erection date is 28th December 2006.
2010 is the new boiler, well, a new turbine which I had to install.
The previous page, new turbine by third party.
Third party.
All right.
Third party.
All right.
So I am comparing the expenses post that date.
And the erection of this machine was 28th of December 2006. All right. So you have claimed this amount from 28th December till 8th of January, or
Yes.
even afterwards?
Yes. I'll just show one from the claim.
Did you claim it also after the erection?
No, after new turbine, no. After new turbine, I am only taking the expenses, additional expenses. The bills have been referred to after that date for calculation. Then 105 second paragraph. As mentioned above, the claimant in support of its claim on account of extra cost incurred for energy and diesel has exhibited 3 documents, 107, 108 and 115. Details of such expenditure. Annexure L indicates cost of minimum contract demand with DVC was 4 crore 67 20,000. Therefore, if the total consumption of electricity is calculated from the cost of minimum contract demand, it would appear that there was extra expense incurred by the claimant. Simultaneously, claimant has also given details of expenses incurred on account of diesel oil in running the generator set. I do not find that there is any cross-examination effectively made by the respondent's counsel to the claimant witness on such account. Without having any contra evidence from the respondent against such claim of the claimant on account of extra, I accept the claim of 56,75,000. My lord, so if I just show your lordship now, my lord.
No, I don't understand what is the difference between C and D. D was increased cost of electrical energy, which you substantiated by DVC.
Yes.
The minimum contract cost you deducted from the total DVC bills.
Yes.
That for that which you produce the DVC bills and the minimum contract demand, and also the
diesel generator
set. And what is D then?
Claim number D.
D. Sorry, C. That was D.
Just chart.
Previous page is D. D page 105 internal page, the middle of the first.
There are 5. If I just show the table of the award at page 108, which contains the description of the claim also. We are on claim number 4.
4 is
on account of increased cost of electrical energy and extra expenditure on high-speed diesel oil incurred by the claimant.
That is D. C and D. C have been granted 56 something, and D have been granted also.
C and D
are related.
I think serial number 4 is together he has done, my lord.
I think so, because D, otherwise previous page, no amount has been quantified for D.
Oh my lord, I think prayer C, C is serial number 3 of page 108 on account of repairs and maintenance incurred by the claimant. Your lordship comes to the award 108, there is a table.
Yes, is it that I
So
have it.
serial number 3 will tally with prayer C, 32,89,695.
But the discussion on prayer C starts
Is
from second
earlier.
paragraph.
No,
Starts from
discussion.
second paragraph. Previous to that is D.
That is 100, I think.
Page 105 you are reading. The second paragraph, page 105, leads to C. And there the tribunal says if the total consumption of electricity is calculated from the minimum cost. So that pertains to D apparently. Simultaneously, the claimant has also given details of this. So D and C, I don't find any difference actually. Your statement of claim, if you have C and D, you can ascertain. C and D appear to be the same. D also says claim by way of increased cost of electrical energy, which is also C. Extra expenses, it says.
Energy. Oh, I think here, Malo, this
apparently, Mr. Shen, C is the generators, the diesel oil generator sets which you had to deploy, and D is that DVC. We don't. I don't.
It is actually split into two. One is the electrical energy, and one is the diesel generator set.
So then,
if I show from my statement of claim, this is this figure 7 crore 56 is comprised of first the
C and D are combined in 4 of
Yes.
page 108. 3 is something else. Repairs and maintenance.
that is a different one.
That is a different head altogether.
Yes.
So 4 has to combine C and D, because also at page 105, D has not been quantified. Only after D discussed, allowed, and then comes to C, and I don't understand this.
Because D, our prayer D is combined.
It was 7 lakh for D.
7 crore.
So 7 crore for D. Only 7 crore.
7 crore 56.
But 56 has been separately awarded under C, prayer C, page 106. And if you take item 4, then it's 7 crore plus 56, 75, 686.
It is, but if I just take.
D is confined to 56, 75, 586. If you please take first paragraph, page 106, and the chart, item 4, you can see that 7 crore plus this 56, 75, 686. So was D confined to 7 crore only? If you have the prayer of the statement of claim.
Yes, I'll just show from the statement of claim.
You can just yourself also see and tell me what was the claim for under D. Must have been 7 crore, otherwise it doesn't add up.
Yes.
Your C has been accepted on 56, 75, 586. And 4 includes that, exactly that, plus 7 crore.
Yes, if your lordship comes to paragraph 48 of my statement of claim, this is in volume 4, AP number 1.
Now,
এখানে এই ব্রেকআপটা দেওয়া আছে। হ্যাঁ, ভলিউম 4 AP নাম্বার 1। এই পেজটা কত এটা? 535 ভলিউম 4। (535) paragraph 48, kindly see the last line. As a consequence, I'm reading from there only.
yes, so then this covers D, your prayer D.
Yes.
So, but the discussion, I accept claim of claimant of 5675 something, which is C, that then pertains only to, that is something else. The figures do not tally. Because page 106, the tribunal says I accept the claim of claimant at rupees 56 something. That should have been 32,89,695. Your C is that 32 something.
That has been discussed earlier.
No, but
prayer C, repairing, is from page 99. if your lordship sees that, that has been discussed earlier. I'll just show that.
No, that's
That
fine.
we have placed on the earlier day. I think this spreads just kindly comes once, page 99.
Page 99.
It's
Yes.
this paragraph at the middle with regard to claim made by the claimant of 3269 on account of repair and prayer
Where
fee
does
of the.
that end? Let us see where
Yeah,
it culminates.
It ends at
See where is the adjudication.
that adjudication is still 102. Till 102. Accordingly, I allow the claim for a sum of rupees such and such.
But then E is
No,
this E should be C.
This should be C, my lord.
It should be C.
This should be C.
There is a gap there.
E we have not got. E have been rejected.
So this should be C.
Yes, that is C.
And then
my lord,
he comes to page 106. What is this? Prayer C of the statement of claim is allowed. He couldn't allow C twice. And the amount is also 5675 is none of your claims.
That I think there is an error. It should be 7 crore 56.
7 crore 56 and not C, but D.
But D. Because the entire discussion is on D.
Yes, exactly.
Entire discussion is on D. And 7 is missing. And
7 is missing. That also they did not point out this discrepancy, but there seems to be there's a confusion regarding the heads only. Discussion is there. Proper discussion is there.
Why he has come to the conclusion that this claim should be allowed, that there is a detailed discussion is there.
Page 102 E is allowed. That should be C because your claim tallies with that C only. And there also repair, yes. So that E is an error at page 102. That should be C, and this C should be there are several errors.
Yes, that has
106 C should be D, and the amount should be 7 something.
7 something.
7 added to that.
And that your lordship will read with finally, my lord, page 108, where he has.
Yes, 108. We are only after comparison with 108.
We can find that inconsistency.
Let's continue with E now.
E is rejected, so my lord, we are not going into it. So, if your lordship has seen that table at 108.
Yes. E is rejected.
Serial number 2 and serial number 5 is rejected. So, we are only concerned with serial number 1, 3, and 4.
Which are 3 and 4 correspond respectively to C and D.
Yes.
And 1 is A, must be. I mean,
1 is A.
A or B, I don't know.
1 is A. 1 is A. Serial number 2 is B.
Yes.
Which is not granted, and C and D.
Extinction of price of turbine. This was the price of the turbine.
Yes. This, my lord, I made my submission on the first day.
The entire cost you have asked for.
Entire cost
of the turbine, but you operated it in.
Not as per the contract. It is only a trial run which was going on.
Oh, that is your point. Other point.
Yes. It could not function. That is my case, that I did not generate the electricity. Therefore, it was a breach of the condition.
But some electricity you had generated, but that has not been taken into.
That is not.
That would have offset some of the bills of the.
But it was not a commercial run. It could not be operated commercially.
Very well.
So now.
So you say the commercial run never started?
Never started. Could not start. And those documents are also on record.
Yes. Documents showing what?
That we could not exploit it commercially.
Documents in of what nature?
Correspondence. May I show one?
No, you can show it later. I'm just trying to get the framework of this thing. He had shown, he had argued earlier.
Yes.
That I remember.
My lord, and what your lordship is now concerned with, my lord, the finding in the award, whether, my lord, it is perverse, suffering from
Perverse,
perversity.
one of the plausible views we don't interfere.
Yes. And whether it is, the conclusion is one of absurdity. It is going
Yes, otherwise quality of evidence reappreciation doesn't happen.
doesn't
Definitely.
it is only something to be said, which the other side can point out, that this is a most material document. Material or not is again irrelevant. This is a document which is not considered at all. And if they can show that had it been considered, the plausible view might have been different.
Perversity is either document which is most German is not considered, or the reverse.
Yes.
Extraneous document considered. Either of the two. And this otherwise reappreciation of
So
evidence.
here, my lord, if your lordship has more or less seen that the arbitrator has proceeded on the principle of section 59 of the Sale of Goods Act. Now, first of all, whether it has to be shown that 59 does not at all apply. So he could not have taken recourse to the finding based on section 59. That my submission was, the complaint which we are making goes to the root of the contract.
Yes.
That it was incapable of the generating electricity even for my captive power plant. So if that is so, that is not something like a warranty collateral to the contract. No. It goes to the fundamental root of the contract. And I have an option under the law either to continue with the contract, not terminate it on account of a fundamental breach, which I have done because I have repaired, tried to have it workable, given them a chance to rectify, but even again did not work. So that is my action showing I am not treating it as a condition at the first instance.
It's under compulsion you paid the repair charges also, which you are not wanting recovery of.
Exactly. So, therefore, if these two conditions are satisfied, then section 59 of the Sale of Goods Act will apply.
Right.
And once the condition for sale of goods apply, then the necessary consequence is my claim for extinction of price.
Right.
And in addition, the second part is damages. So, these are the two claims which have been allowed by the arbitrator, my lord. So, may I go on to the next part?
Yes, absolutely. I have understood this part.
So, the next part, my lord, is not something to do with the substantive law. It is, my lord, the point which has been taken is one, on the ground of making of the award is vitiated by fraud. And what is the fraud? The fraud is not something which is a direct allegation either against the party or the arbitrator. They are trying to say on the basis of some documents that trying to create a doubt on the arbitrator's physical and mental incapacity, infirmness. Now, one fact, my lord, which your lordship will keep in mind while thinking about this, my lord, whether at all this point can be raised at their instance. Why I say? Kindly see this date. Date is 22nd of July 2020. 29th of July 2020 is a dissenting award, dissenting opinion. The claimant filed application under section 33 on 21st December 2020. Respondent participated in the proceeding on 18th January 2021, 29th January 2021. So, my lord, I am participating before a tribunal. I do not contemporaneously, immediately after participating, come and say or raise an issue that there is no question of participating in a 33 proceeding before a person who is not physically fit. Because I have personally attended. I mean, I am trying to put their case. You have attended a proceeding before a person. You don't ever raise an issue that there is no proceeding at all. The tribunal is not in a position to conduct the proceeding. You have allowed the proceeding to continue at the 33th proceeding stage. This is number one, whether having participated in a 33 proceeding and not raised any issue about the mental infirmness or physical infirmness of the concerned arbitrator, at the 34th stage, because this is not a subsequent fact you are saying which has happened after this 33 proceeding. Your case of infirmness is something which has occurred prior to the original award, according to you. You are not saying that you cannot make out a case that I have come to know subsequently. If there were no 33 proceeding, you could have said that how will I understand it?
33, they participated, they submitted to the jurisdiction of the same tribunal and did not raise this point contemporarily.
Second most important fact is, Manoj, this allegation is coming from the petitioner. They are relying upon another opinion of another member of the tribunal.
Yes.
The learned member of the other member of the tribunal does not say anywhere that I could not agree or continue with the proceedings because the presiding member was infirm, physically unwell, mentally incapacitated. Therefore, there was no question of having any proceeding with him. He is the best person because you are relying upon his opinion. That opinion is not corroborating your stand. So, my lord, they cannot ask the court to rely upon certain factors.
But Mr. Shen, he does not say, express his opinion either way. He does not, I mean, because he says merely, as far as I can recollect vaguely, I'm paraphrasing that a copy of the majority award was not given to me. That's why he passes.
No, I understand that, but kindly
not
see,
say that that's
but
either way.
But isn't that is the most.
He only gets a copy of the majority decision subsequent to its passing.
Well, kindly consider it this point of view. I am a person in the tribunal. There is another person who is sick, who is not well.
But he may not know because when the majority award came, he did not know about it, according to him. So, it was subsequently served on him. So how is he in a position to know either way?
But the allegation which the documents which the other side is relying upon is of a period prior to that. So, my lord, our learned tribunal member, the dissenting member, my lord, it is not his case that
no,
I could not have any deliberation with him because he was unwell.
No, it is not his case.
So therefore, what I'm saying, there must be some, even to be prima facie with the case which is being made out, there must be some corroborative factor.
But the dissenting arbitrator, dissenting member, Mr. Shen, he did not know about the majority award at all. Its veracity.
I'll just show your lordship
that yes,
language which has the.
Let us see the language once again.
Page 111, no? এখানে আছে তো পেজে আছে 111. Yes, kindly come to 111. Volume 1, AP number 1. 110 from, you kindly see from 110. (23A)
at which page?
It starts at page 55.
Yes.
No.
53.
53 minutes. After expiry of the time stipulated, respondent filed notes of argument on 2nd of March 2020. The claimant filed during lockdown and forwarded to me on 10th June 2020, and stamp papers were received a few days thereafter. Stamp papers from the respondent were received even thereafter. Upon receipt of notes of argument filed by the parties as above, the matter was taken up by me for consideration. On 22nd July 2020, I was only informed that presiding arbitrator and co-arbitrators allowed claims of the claimant. So his reason is not being able to agree to such conclusion. I decided.
This is what I said, Mr. Shen. He
Yes.
says on 22nd of July, I was only informed that presiding arbitrator and others have allowed claims. Not being able to agree, he passes it. So he does not have any knowledge about the state of mind of the presiding arbitrator when that award was passed. He only gets a copy of the award. The hearing was concluded previously. He gets a copy and comes to know that the majority has given an award. He was not in a position either way to express his opinion. He was not there when that majority opinion. He was not even consulted. That's his stand.
That is his
He
stand.
does not know anything about the majority award. He's given a copy. He says upon reading it, I don't agree. And then
Very well, but this is what it appears. But what I am trying to make out a case is that
he could have had a better case if the dissenting arbitrator had also said. But that is the quality of his case. That does not vitiate his argument otherwise. Because second arbitrator,
so then the question arises.
does not know. He was given a copy of the majority award. He writes his dissent.
I am saying that it would have been easier for the court to even consider his plea, despite there being
He would have a better case if the dissenting arbitrator. Obviously, he would have a better.
I am saying that he
But
would have a case.
Why do you say that? Because the dissenting arbitrator does not know about the state of mind of the presiding arbitrator at the time of passing of the majority award. He doesn't say anything about his knowledge. He says rather that I was only informed afterwards, after passing. So he shuts out his knowledge about the majority award, its veracity, the state of mind. Nothing, he knows nothing. He's given a copy, he writes his dissent.
But that can we infer from here that he knows nothing. He only says, he gives the reasons. This is only the reason of his dissent, that I do not agree to the conclusion of the arbitrator. So
he was not there when the majority wrote the award, so he doesn't know anything about that as per his dissent.
But he
was only informed later on that it has been passed.
It is.
So might have been. It might be theoretically, Mr. Shen, that the presiding arbitrator was not in a position. He was debilitated at that point of time, and this majority award is tainted by fraud. But still, the dissenting arbitrator does not know anything about that. That might be the case. So we cannot rely on his, because he says that he did not have any knowledge. He says he was informed. So we cannot rely on his knowledge either way.
But only thing I was.
You would have a better case if he said agreed with them.
That is the point. Not only a better case, I would say he would have a
almost foolproof case.
Almost foolproof, because
unless you mean fool to be the judge. I mean, foolproof here can only mean the judge is a fool. After all, foolproof only the section 34.
But after all, Manoj, it is a very allegation is a serious allegation.
Yes.
And therefore, the court
definitely
court has to consider whether
highest quality.
Highest quality. Yes. So that is what, Manoj, I will be
and this is an arbitrator. This is a fraud apparently. I mean, the machination behind it was also of the other arbitrator. Because if the presiding arbitrator was not in a position to write the award, then it should be the other majority award writer who was a part of this fraud. Has to be.
That is.
There were 3 arbitrators. One does not know about it. Presiding officer, he says, is not in a position to know. Then
but that also we don't know what they are trying to hint at. So
they have
again, I say that
he was not in a mental position to pass the award, presiding. So it must have been either you or you in collusion with the other award writer, because the other award writer, majority award writer, did not dispute this award. But he is a part, he signs the award. So he must have been, he had to be instrumental in perpetrating this fraud, and you might have colluded with him.
That to that extent, they have not gone. If your lordship will see their grounds, they possibly could not go. Because
no, that is the necessary inference which we have to draw. If the presiding arbitrator was not enough, if we accept their
I accept, my lord, what you are
only the remaining majority arbitrator, the award writer,
definitely comes to the mind.
He is the only person who could have been responsible. Otherwise, he wouldn't have signed.
Then that is why I say
he had to be a party to the fraud.
That is why, my lord, I am trying to submit this, my lord. This kind of allegations
very serious,
maybe easy to make.
Absolutely.
To raise a doubt.
Even Mr. Chandra would agree with that. A fraud of this nature, definitely.
Yes. But question is, my lord, how will the court approach that situation? It is very easy to raise a doubt in the mind.
Anybody can say it.
Anybody can say,
Right.
anybody can raise a doubt, and once it is there on affidavit, it becomes all the more difficult. Now, but question is what should be the approach of the court in such a situation?
Court should be absolutely sure, definitely,
Yes,
that it could not have been passed by
could not have
in
been
his
passed.
mental frame.
And then, my lord, how will the court, if I may ask this question, come to the conclusion in the absence of these, what should I say? In a suit, the position is a different thing. Lordship is going to the root of the allegation in the suit, examination, cross-examination. Beyond doubt, one is coming to the conclusion, yes, these documents are genuine documents. They have originated from the source. So those examination in a suit matter, it is completely different. Your lordship will satisfy your lordship's conscience. Your lordship has the mechanism to satisfy your lordship's conscience. Unlike this kind of a situation, where, my lord,
Yes.
how I really, my lord, have not understood to what extent the petitioner can prove this. It is not sufficient that you just raise an allegation.
Definitely.
So, my lord, I would be. That is why I thought that if
that would be a very good indicator that this is tainted by fraud, if the dissenting arbitrator said something. But he has not said.
He has not said. So, my lord, they can, once they are relying upon the dissenting opinion also, they can't get support of their allegation from that opinion. That was what I want to make. So even that piece of strong evidence has gone. But something which I say is really in my favor is their participation in the 33 and immediately not pointing this finger.
Definitely, yes.
That, my lord, is something which should, which the court should view with suspicion, that these allegations, that whether it is being made in good faith or not.
Right.
At this stage, my lord. It is, my lord, or whether it should be qualified as a reckless allegation.
Yes.
Somebody has to take some responsibility, mere by way of affidavit, annexing some documents, whatever. We can't have 2 + 2 = 4. The person may have been in the hospital, but then you cannot just come to the conclusion that it was impossible. ওই জাজমেন্টটা দেখিয়ে দেবো তাহলে। This, as there is a coordinate bank judgment on the extent or explanation of fraud. What is the
in 34, in section 34?
It is in 36.
Arbitral proceedings, yes.
Rahul Kumar Thakur to?
Can mention the citation in the microphone so that
yes, I'll
yes,
have to give them a copy because this is from our unreported.
Is there anybody on their side?
Well, it's actually my instructing counsel was actually down with chikungunya.
Oh,
as a result of which he couldn't be here, Malad, before the honorable court.
You can email to them.
They've chickened out.
I wouldn't say that.
No, but you have to have a copy of this. Let him rely. Mr. Shen will rely on this, and a copy will be supplied.
No difficulty. No difficulty.
Well,
this is by Union of India and others versus Rahul Kumar Thakur.
Right.
APCOM, my learned friend.
Yes, you can, Mr. Chindra, you can just take down the number. APCOM 657 of 2024. 657 APCOM
and the date of the judgment?
657 of 2024, 5th of March 2025.
All right, Malad.
The respondent is Rahul Kumar, Union of India versus Rahul Kumar Thakur. So you'll get it in the website of this court.
My lord.
Right.
Kindly come to paragraph 13.
Paragraph 13, yes.
The issue before this court is whether the petitioners have been able to make out a case for unconditional stay of the award. According to the provisions of law, if it prima facie appears to the court that either the arbitration agreement or the contract which form the subject matter of the arbitral proceedings or the making of the award were affected by or induced by fraud or corruption.
আরবিট্রেশন কনসিলিয়েশন একটা যে কোনো 34 প্রসিডিং আমার দিয়ে রেখে দেবে। থ্যাংক ইউ, সরি প্লিজ কন্টিনিউ।
Yes. The or the making of the award were affected or induced by fraud or corruption, an unconditional stay of the award can be granted. The case of the respondent was not that either the arbitration agreement or the agreement containing the arbitration clause was affected or induced by fraud or corruption. Allegation was making of the award was induced by fraud and corruption, and the learned arbitrator acted on the misrepresentation of the respondent and passed the award. While doing so, extraneous documents were taken into consideration with the intention to allow the claim at any cost. When the respondent failed to establish a case of breach, loss of profit, 2007 circular was applied by the arbitrator, holding the same to be a policy guideline. Then my lord kindly comes to paragraph 22. After defining, quoting the definition of fraud in paragraph 22, the expression making of the award would mean that the award must have been obtained by a party to the arbitration upon suppressing material evidence or by making false statements before the learned arbitrator in order to take an unfair advantage over the other party. The petitioners have not been able to prima facie establish that any of these situations had arisen in the making of the award. There is nothing on record to show that vital documents had either been concealed or false statements had been made before the learned arbitrator, which had a positive link with the facts constituting and culminating in the award. In the case in hand, arguments of the petitioners were on the ground that both the respondent and learned arbitrator wrongly relied on the policy of 2007, and the evidence of the railways were not given due credibility by the learned arbitrator. The specific allegation was that the learned arbitrator had failed to take into consideration cogent evidence and had allowed claims without the responsibility of having established the basis of claims. Corruption by an arbitrator will mean a moral obliquity. An honest mistake or erroneous appreciation of law may not appear to be reasonable to the court.
Why are you citing this, Mr. Shen?
Because
It has
this
no
is a-
nexus with the present matter.
Because this, my lord, burden of proof, paragraph.
Here it was argued that the arbitrator did not rely due credibility, give due,
No,
due
but
credibility
what
to a
is
policy.
my lord,
That was an error, obviously. That
Yes,
that
but-
could not be corruption.
kindly see 24. What is the burden of proof? Because what you are saying, the other side is saying is that it was not possible to make this award through this gentleman.
But here it was an allegation of sort of corruption. I mean, the arbitrator moral corruption or whatever.
Moral, but
But that is, our fraud is much wider than that. Fraud has contemplated 34 to be. Because Mr. Shen, my limited perception of this language of 34 is a bit different. It can be the making of the award was induced or affected by fraud.
Yes.
Generally speaking, by going by the language, an award, a making of an award is induced by fraud when a party induces it, induces the arbitral tribunal. So that can be intra-arbitral fraud. During the proceeding, there was some fraud perpetrated on the arbitrator. And affecting the award, making of the award is much wider. The award itself is fraudulent, suppose. So it was not induced by fraud. The award directly is affected by fraud. Their case is on the second limb. The award was not induced by any fraud in that sense, intra-procedural, you perpetrated some fraud. No, you did not induce. They're not saying that. But here, the fraud, the award itself, the making of the award itself is affected by fraud because it was not written. He was not in the, yes, he did not have the incapacity.
Incapacity vitiating the making of the document.
Capacity of such a nature that he could not have made this award.
So that is what, my lord,
Therefore, meaning thereby that this award was not made by him at all, consciously. So
but question
here, this judgment is not relevant at all.
Only on the principle, what is the extent of the case which has to be made out? What is the burden? It is not a mere allegation.
But here it is in the context of this case. Corruption was alleged. It was also further alleged that the arbitrator did not give due credibility to a particular policy which was placed, which is an evidentiary thing. I mean, the arbitrator thought it was not relevant, could be at best perversity. Here, fraud was not.
I am not going into the ground, but I am only on the requirement, as in paragraph 24, which says which
Corruption.
though in the, which is on the plea of corruption, but the line which is important is the burden of proof.
Is rather high. Why rather? Very high.
Very high.
Very high.
So
Yes.
that is what I want to
Absolutely. No,
emphasize.
everybody has to
I
give
know,
it.
Malad, that this is quite basic proposition.
Not only that, you're right, Mr. Shen.
So-
We have to agree to this proposition. There
It
cannot
is
be any
very
quarrel.
difficult to come across a very similar case.
No.
But the
But this is absolutely dissimilar. I mean, here
principle which is emerging,
that's settled.
that is
You
settled.
got to get 100 judgments of settled.
But those were, Malad, in the context of establishment of fraud in civil matters. There are a lot of judgments on that.
No,
Particular-
Section 34 and civil suit misapprehension, there are some advantages, some disadvantages in alleging fraud. The advantage is that the disadvantage in the alleger of the fraud for them is that it has to be on a very high footing because of Section 5 of the Arbitration and Conciliation Act also.
Yes.
The least interference policy, of course. And it's easier for them because 6.4, Order 6.4 is not strictly applicable. So if the court finds,
No, but that there I want to say, Malad, simply because
there also it has to be of a very high standard, no doubt.
Yes.
We say an award is fraudulent, has to be very high standard, Mr. Shen.
Yes.
No judge. I mean, this judgment is. I'm taking this judgment, but no judgment is required for that. Absolutely, fraud is something very serious.
but that is a basic proposition, Malad, which we have
Has to be adhered to.
that
No
is-
doubt. Nobody can doubt that. Nobody will say fraud has to be proved. I mean, preponderance of probability merely. It has to be higher than that. Somewhere in between preponderance of probability and
But some
beyond
judgment
reasonable.
my junior have already cited. Your lordship has already
Regarding fraud,
yes.
yes.
Those have already been taken note of. I think 76 1 SCC 747 has been.
In any event, I'll be taking written notes from both
Written
parties so that I don't miss out on any of the judgments in any way. And I've taken notes also. Extensively argued.
Okay. Now, Malad, since it has fallen from your lordship, Malad,
Exhaustively argued, actually. In the sense of exhaustion. He was exhausted after the arguments.
that is why I got a chance.
You got a chance.
If he was not exhausted, I would
You
have
would
lost
have
out
come in.
on this.
No, definitely not.
Not my juniors have found out one judgment, but I will rely on.
Ask them to stop finding out new judgments. Fraud sufficient judgments have been found out.
No, this Malad, just the observation which fell from your lordship, Malad, that
No, you cite whatever judgments
Yes.
you like. But
the nature of
the exercise should be stopped now. No new.
no. The
Fine.
nature of the allegation is such that it is also casting
Expert.
on the other person.
That is what I said. That
Yes.
the other person is the only
So
person
therefore,
who has to have knowledge, even if claimant did not have knowledge.
because yes, though in an arbitral award, section 34, the principle, there is no question of impleading tribunal.
No question.
But here, what is happening here?
He doesn't get a chance.
Personal allegations are being made.
In a
Even if that allegation of that nature is not there in the
by
pleading,
necessary inference.
automatically some doubt is coming.
Had to be. His involvement had to be there. His or her involvement had to be there.
So therefore,
Because the only person, other person is he.
So-
If the presiding arbitrator was not in a position.
my lord, whether the interest of justice would have demanded that in such, forget about this case, in such a situation,
To be implemented.
just one paragraph,
Which High Court? Our High Court.
Justice Sanjeev Banerjee, of Division Bench of Madras High Court.
Justice Banerjee had this thing. Yes.
But he did not say that in all, he pinpointed an exception. Kindly see paragraph 2.
Yes.
For a start, the name of the second respondent is deleted from the array of parties. It is a pernicious practice in this court to implead arbitrators or arbitral tribunals when there is no need to do so. Often arbitrators are embarrassed upon receipt of notice. It is only in a rare case where a personal allegation is made against an arbitrator may such arbitrator be impleaded. Just as in case of revision on an appeal, the lower court judge manning the lower is not impleaded as a party in proceedings under 34. Arbitrator members of it are utterly unnecessary party unless personal allegations are leveled against them that would require such person to answer the allegations. This is just a rider that if on the suppose they have not discharged their heavy burden to the extent your lordship feels it is necessary, but still it is having some doubt on the mind of the court. The court cannot just brush away the allegations. Therefore, to come to a finding that yes, fraud is vitiating the award would otherwise amount to condemning someone.
So you are relying on the reverse proposition which was held in this case
Reverse.
by relying on this sentence.
Yes, relying on this sentence. In a particular case, if direct allegations,
There no allegation was made directly. You are right on that.
implied.
But even if
I am
implied,
saying it is for the court.
by inference, because he had to have an involvement if there has to be a fraud here.
But I am not going to that extent.
No, you're not.
But
We
I am only saying this that it is for the, because the court has to come to the conclusion. A party is only raising a doubt.
Yes.
Once a doubt is raised, court is finding that they have not discharged their burden. But still the doubt remains.
Court can always call the out.
Therefore, my lord, before finally, my lord, condemning that.
That is one of the difficulties of retired judges taking up arbitral proceedings. You can be called by one of the judges who you taught law, maybe. Yes. You argued sufficiently on fraud. Every facet of fraud is now clear to the court.
We will learn from your lordship's explanation.
We learn from you and then vomit it in our judgments. Paraphrase. It's the council who teach law to the judges. It's always your endeavor, both of you. I mean, which is reflected in the judgment. Bad arguments, bad judgment. Bad argument, bad judgment.
That is previous generation. But we are nowhere close to them.
No, your judges are also like you. We forgot that. You are of this generation, your judges are also of this generation. We are also not of the previous generation. And previous generation, I don't believe this, Mr. Shen. Everything of the previous generation was good.
But
many of the things in previous generations were not good. You see some of the old judgments by established judges whom we revere, but you won't be able to agree with those. I'm very open-minded on these things. Nothing belongs exclusively.
I am only saying that
Stature of the
judges learning from council, that is previous generation. That is previous generation.
Sorry, I'm
not our generation council.
Very good. Let us stop there. Yes.
Now, the other aspect is the signature and the reason. 31, the requirement where in case of a dissent,
yes.
the reason has to be there. Kindly see 31 once, my lord.
Yes.
31(1), an arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. For the purposes of subsection 1, in arbitral proceedings with more than one arbitrator, the signatures of the majority of all the members of the arbitral tribunal shall be sufficient so long as the reason for any omitted signature is stated. Now, my lord, my respectful submission will be this, my lord. This reason, first of all, the dissenting opinion itself is the reason. I am giving a dissenting opinion. Existence of the dissenting opinion is the reason, and in my case, the dissenting opinion contains the reason in page 111, which your lordship remembers.
But that argument, Mr. Shen, could have been valid if the dissenting arbitrator knew about this previously. But he came to know later. There is no reflection. This majority award was passed without any reason as to why his signature was not taken. Not a single line has been devoted as to why his signature could not be available or he could not be made aware of this.
But my lord, kindly see, my lord, is that
in the majority judgment, there is no reason reflected.
That I understand. But the
post facto, the dissenting arbitrator cannot provide a reason to the majority judge. That would be, turning the theory on its head.
But kindly see, if your lordships
yes, please,
subsection 2 once more, in signatures of the majority of the members of the tribunal shall be sufficient so long as the reason for any omitted signature is stated. But the reason has to be there. But is it?
You may say, Mr. Shen, maybe your argument could be that Here there is no. This is not a case of omitted signature. No signature is omitted. The award is truncated. Truncated in the sense that majority award is differently delivered, separately delivered. There is a signature of the dissenting arbitrator, and his dissenting award is also circulated.
Circulated
So,
with a reason.
so there are the award is one, it's truncated, and majority award prevails. Since dissenting arbitrator has passed an award with a signature, so
That-
you may say 2 is diluted. That may be your argument, but that's a bit doubtful. I mean, shouldn't the majority award itself contain the reason?
That is not there in the statute. That specific requirement that the majority, because majority, once the majority award is being delivered, it itself is not a fact that it is not unanimous. There is in existence some other opinion which is not in tune with the majority. If that award does not see the light of the day, the minority opinion does not see the light of the day, then it is absolutely clear that it is not in
That
terms
is what
of-
I'm saying. There is a dissenting award with a signature.
Yes. And also, my lord, kindly see, there is an amended award also.
That is signed by all.
No.
By these two.
But also that contains the reason. Amended award.
Achha, let us see that.
Yes. In fact, their prayer in the 34 is with regard to the amended award.
Has to be, because it has merged.
They have not annexed also the original award as part of the 34. It has come by way of a supplementary affidavit.
No, but Mr. Sheth, the amended award, the original award is merged in the.
Principle is that because the amended award cannot exist independently. But
No.
if I suppose I am filing an application, I have an obligation to say that the original award as modified by the amended award, both of which are under challenge.
They have not said that.
Kindly see, my lord, their
That's a bit technical.
I will again, my lord, they have again
The decree is modified. So they challenge the decree in the modified form. So it merges in the modification.
Let us see, my lord, once the amended award.
Yes.
46 of volume 1. AP1. Kindly see at 48, no? At 48. Kindly see page 47. After completion of
Page 47 of
AP1 volume 1.
Yes.
After completion of hearing of the parties, we such and such co-arbitrator had jointly made and published our award on 22nd of July 2020. Such and such co-arbitrator had made and published his award separately.
Sorry, this is page?
Page 47.
47.
Paragraph 2. First paragraph at the top.
Yes, yes, after completion.
We such and such had jointly made and published. Co-arbitrator had passed his award separately.
That is not a reason.
That is not a reason, but in the meantime, that dissenting opinion has come. Dissenting opinion has that reason. So it is, the reason has to be stated.
What is the reason given here? Why his signature was not taken?
That he has said that the page 111 of that decent minority opinion, he has said that I was not aware. That is why I could not agree with the claims.
So you say that we have to look at the amended award as it stands now, and in the amended award, because that is what they have challenged, and the amended award contains a reason that signature is not there because he dissented.
Yes.
At the first instance, he had dissented. So now in the amended award, I give that reason. Very good.
And the reason is also there in that dissenting opinion, express reason. The amended opinion, amended award records the fact that there is a dissenting award. It is only the recording of this fact. There is no reason. The dissenting opinion records the reason of dissent.
That is the reason of dissent.
Yes.
The reason has to be for his signature not finding place in the award.
That is because I did not agree with the claims. That is what the
He says I did not know of the majority.
And I did not agree with the claims. Suppose, my lord,
did not. That is in present tense. I did not have I did not know of the award. Subsequently served on it. When it comes to me, I don't agree with that.
Yes.
He could not have disagreed earlier because he had no occasion to know that a majority award was passed.
But may I just read once more, my lord, the
How
line?
could he have a dissent if he did not know that an award was passed?
But may I? He
That
is
is what
saying, but he is saying
Let
here,
us see what he says. Page 111,
Yes.
111. On 22nd of July 2020, I was only informed that presiding arbitrator and other co-arbitrator allowed claims of the claimant.
allowed claim.
Not being able to agree to such conclusion, I decided to write this separate award.
judgment.
So before knowing, he was not even informed about that award, he says. On such and such, I was only informed that they had passed an award. Allowed claims, only past tense. Let us forget the tense. How could he did not know of the award? How could he have a dissent at that point of time when the majority award was passed?
So, my lord, the point is, my lord, the purpose of the section is
when the majority award was penned, Mr. Shen, there was no occasion for the majority award the majority members also to know about the dissent also, because it was never circulated to the other member. It is not expressed in that. Even if it was expressed in the original award, majority award, that yes, there is a dissent, he did not sign, we could have understood. Or cursory one line. Nothing. As if that is the award, but two sign. There is no mention even of why there is no signature of the third arbitrator. Merely this is the award passing.
that is what I was thinking, my lord. That
Post facto, I mean, it has been, yes, just because there was a section 33, you take the advantage of that.
Because ultimately this is what they are challenging. And when they write that there is a dissenting award,
yes,
so that is the
by then they know that there is a dissenting award.
And therefore, that itself, my lord, is a reason for the signature not being there.
No, it does not say that because he had a dissent, we did not put his signature.
No,
does not say
that is not there. That is not
it
there.
only records he passed a separate award.
Question is, my lord, whether your lordship is thinking probably that whether that reason must be there on the date the majority award is signed.
Precisely.
But
I'm saying that only.
I would
that
like
can
to,
only be that can be the only explanation of 31(2).
But your lordship will kindly consider only this signature of the majority shall be sufficient so long as the reason is stated.
Therefore, it is speaking about the majority award.
It may not be there in the majority award. It may be in a.
Where else can it be?
In my minority opinion, if I give a minority opinion, that itself is the reason why my signature is not there in the other
What
award.
if you say that I was not informed of the original award? That vitiates it. Vitiates in the sense that the reason is taken away. If I was not informed, how can I have a dissent on a thing which I don't know about? I cannot have a retrospective dissent, Mr. Shen.
But
when award was signed by the two, This person, the third member, he was not even aware of that. So today, two of us are signing the judgment, the award. The third arbitrator doesn't even know about this, as per the dissenting award. I don't say anything why his signature is not there. Both of us pass the judgments. And the third judge, later on in a separate award, he says that I was not informed about that. Now I come to know, I don't agree, so I pass the separate. Yes, amended. Yes, they are challenging the amended award, and technically you are right. At the
Just one correction, Manoj. I don't want to interfere, but I'm challenging both the awards at page 42 of the same volume. Both the awards are challenged.
not only that, Mr. Chindra, probably even if you challenge the amended award, it has merged it to this amended award. So a challenge
Yes.
to the amended award means a challenge to the substantive award also.
Yes.
There
Yes.
would
Yes.
be hyper-technical if you say it's not so.
So,
Yes.
my lord, if
No
your
difficulty.
then your lordship will have
And
to,
they have challenged both also, they're saying.
your lordship will have to read both the award, the original majority award, then the amended award, and the dissenting opinion
True.
to come to a conclusion.
Yes,
whether
Mr. Shen,
this-
they actually say that. Set aside the amended arbitration award, including the original award.
But the original award was not there.
That has been put in later.
No, if I go by that prayer, then my lord, lordship will have to see the requirement
So
of
very well, Mr. Shen, let us set aside the original award. You be content with the amended award.
No, they are not challenging
There
that.
will be no meaning to that. The original amended award is nothing without the original award.
Of course, it's not. But,
Then don't
but-
rely on any page. Don't touch the original award, and we go by only by the amended award, and we say there is no sufficient reason. Let us set aside the amended. There is uphold the amended award, but set aside the original award, and let us see what will be the impact of that. that is a technical.
let us see.
Don't go by Mr. Chadda alone.
No, I my lord,
Anyway, I have taken note of that argument.
then my lord, this again, my lord, then one question is whether this, even if your lordship construes that the reason has to be there on the majority award, then my lord, last submission would be that has been corrected
In the amended award,
in the amended award.
I've taken down that point only. Amended award contains reasons.
Contains
That is your argument.
But your lordship is not satisfied with that the minority opinion also contains the reason. Maybe not on the same date.
No, minority opinion, Mr. Shen, I am not agreeing with you on that, subject to being corrected by you, because the minority opinion cannot post facto validate something which is invalid, if it was invalid. Because minority award only says that I did not know of the award. Whatever is said in the minority award, it's subsequent. So it cannot go back in time and provide the reasons for his signature not being contained in the majority award. He cannot do that. He has to have a time machine then. He cannot go back in time and say that at that point of time it was justified because I now dissent. Because when the award was signed by the majority, they could not have known he would dissent.
But then the other question arises, if there is a difference of opinion.
A line will be written in the original majority award. That much would suffice. There is a dissent of opinion, he does not sign. That is what is intended in the statute. They have to say only that there is a dissent. And that's why he is not signing.
In this case, what has happened? The dissent has come
Post facto.
surfaced later.
Yes. Because on that date, relevant date, when this reason was not given, they also could not know that there would be a dissent. Might have been the converse. They might have thought that he would toe the line of the majority award. I mean, we are just making conjectures. Maybe they were confident that that would be done, and that's why they did not give any.
This is my submission, of course, that the statute does not incorporate that strict requirement that the reason has to be stated in the majority award. And
now, in the dissenting award, what reason has been given for his signature not being there in the majority award?
Because he first two reasons, I was only informed that the claims have been allowed, and I do not agree with them.
You say that is a reason for his that is a reason for his not signing.
Yes.
But the majority award does not contain that reason. But you are saying that the dissenting.
But the fact, yes, majority award does not contain
No,
the
but
reason.
we are on a more basic question, Mr. Shen. His dissent also could not have been known to the original, the majority members, because he himself says, I was not informed on that. I was informed later. If I say I was informed of something later, I could not have had a dissent or an agreement on that date. So his reason dissent could not have been a contributing factor. We could read these reasons back into that award. We could have. But if it was contemporaneous,
if we read it like this, not on the day the award was passed, I came to know of this.
I come to know of it now.
But kindly see, on 22nd July, I was only informed, that is on that date when the majority award is signed. So on that date, I have been informed that the claims have been allowed.
All right.
And I don't agree. Not being able to agree.
Very well. Since the date is same, you say it was contemporaneous. All right.
Not being agreeable to such conclusion, which I came to know on 22nd July, I am today writing this award.
Very well.
I am decided to write this separate award.
Very, very, very.
So therefore, this is what we can say, my lord. That
all right. That's a valid argument.
This is a manifestation which has come later.
All right. But on the same day, he was informed.
Yes. On 22nd July 2020.
Very.
If he had agreed, he would have signed it.
Very. I was thinking that the date of information was later.
No, this is the date of the majority award.
Very.
22nd July.
That makes it better for you. Yes. Very. I accept. I accept the argument. I mean,
yes, of course. That is what I
said. That it's a valid argument.
that is sufficient for us.
That's a valid argument. Yes.
Lordship, can I cite this Delhi High Court, which subject to just your Lordship, it's just one paragraph which says, paragraph 97A. Non-filing of the arbitral award this is actually was the greater question was relating to conversion, statement of truth in a commercial matter.
Achha.
Ultimately, this has also been discussed, my lord, whether, and one of the reference was also a non-filing of the original award along with the 34.
You hit my limitation.
Yes, on the point of limitation. Kindly see paragraph 96. 95 and 96. In this regard, it needs no emphasis that procedural defects cannot be allowed to triumph the substantive rights of a party, particularly since, in view of our aforesaid observation, 34 of the Arbitration Act is the only remedy for a party aggrieved by an arbitral award. The said right, therefore, should not be negated on procedural technicalities, and hence for describing an application on 34 as honest, a more liberal view in favor of the party filing the same should be taken. Mere procedural errors or defects thus would not render the filing of application 34 to be treated as honest. Even in general law, objections like pleading not being properly signed or there being a defect in affidavit are treated procedural and curable. Standalone, therefore, they cannot be treated as defects which would make an application filed under 34 to be declared as honest. It is only cumulatively, and that too only after court finds that the above defects have been left by the petitioner while filing the application on 34 with a mala fide intent of only stopping the period of limitation from running without there being an actual intention of having the implication listed.
Have you given the citation? 2025 Delhi.
Oh, yes, sorry. 2025 SCC Online Delhi 636.
Yes, please continue. Paragraphs 95 to 97.
Yes, 95 to 97.
Yes.
Needless to state, it would surely depend upon the facts and circumstances in each case, and there cannot be a straitjacket formula to determine whether any of the above mentioned defects or combination thereof or how many such defects would render an application on 34 to be declared as honest. Similar are our observations as far as changes in the contents of application under section 34 are concerned. It is only when the court finds that the application originally filed by the petitioner has been substantially changed at the time of removal of defects that the court may form an opinion that the original application filed was never intended to be the final application or one which should be listed before the court. Hence, making of minor changes or even addition or deletion of new facts or grounds or adding documents would not ipso facto make the application originally filed to be declared non-nullius. Even it would be the intent of the party that would have to be deciphered by the court. Be that if the court finds that intent was also stall the limitation from running, as some other courts have held, that only a bunch of papers had been filed, that the court would be free to declare such filing to be non-est. We summarize our answer. Non-filing of the arbitral award along with an application under 34 of the Act would make the application liable to be treated and declared as non-est. And the limitation prescribed under 34(3) shall continue to run in spite of such filing.
Here a bunch of papers was filed. No award was filed at all.
No award
Here
was
the amended award in your case was filed.
Only the amended award was filed.
Only amended award was filed.
Not the original award.
Acha, the amended award is at page, which page? The
Amended award,
this page 45
46.
on
Yes.
6 onward.
Yes.
Very. All right.
Supplementary affidavit to cover filing.
Very well.
Though in our case, the limitation will not arise because the supplementary affidavit has been.
That was also within time. That was also within time.
Yes.
Then why are you citing this?
I'm citing because there was no 34.
Only for
and
the
whether-
purpose of section 30.
Whether the
It
court,
became a 34 when they filed the supplementary.
can it be cured? It is saying that it is treated as non-est.
Bunch of papers was filed. It was non-est when it was filed. Supplementary affidavit becomes a part of the main application.
আর কি দেখাবে বলে?
Not accepted. No, but cite this judgment. Give it in your written notes.
Yes, I should.
I've taken note of this. I'll have to deal with this.
These are my submissions more or less. Only thing is, their judgments I can distinguish in the written notes, if your lordship.
Yes, you can just indicate. I mean,
Yes.
on the facts, all on the facts.
All on the factual aspect. Some are there on the signature aspect also, that I can show how it is distinguishable from our case.
You can put it in the written notes also.
Equal to.
Because they have already cited those.
Okay. So, only one judgment which has been strongly relied upon.
Yes, the important ones you may
Yes,
indicate.
kindly see 21(7) SCC.
Yes.
Huh.
Dakshin Haryana.
Yes.
Yes.
Here, what was involved is the question of limitation. From the point of view of limitation, what is the effect of the dissenting opinion coming late? So, in that context, coming on a different date. So, in that context, what is the character of a majority award? What is the character of a minority opinion? In that context, it has been said, the majority award, which is the one which is to be considered for the purpose of implementation or challenge, and that is the date. Even if, and it has been clarified that minority opinion is only an opinion of sort. It is not binding upon either party. So, if it is on another date, that the
that
limitation
cannot be relevant. For
that
limitation will run from the
original.
Majority.
That is so. Therefore, this may not have an impact on the 31(2) case. That it is not going to that extent to say that 31(2) makes it mandatory for reasons to be there on that date. Because as your lordship felt here, that 111 says, I have come to know, yes, there is an award. Today, you have passed an award. But I can't write my opinion today itself. I say in my opinion, which I am writing tomorrow, that I have not agreed with the finding which you have arrived at yesterday. So that is the reason he has expressed. So therefore, that is sufficient for 31(2). Therefore, this judgment cannot be construed to mean that it has to be there on the same day. There is one line in this judgment. So on that basis, probably this submission was made. But the entire context of the judgment is limitation, which is the date for limitation. Then, my lord, there is this ISC project.
ISC projects, yes.
Page 22 is the judgment, my lord.
Yes. What is your line of distinction of this?
Here, kindly come to paragraph 32 of this, my lord. Paragraph 32 will distinguish this, my lord. Kindly see paragraph 32, which is at page 33.
Yes.
These principles must be applied to the undisputed facts of the case. A, the signature of arbitrator A does not appear on the award. Impugned award does not disclose any reason for the
So you're
fact.
relying on C.
Yes. There is no separate dissenting award circulated by him.
Very good. Yes, since there is a dissenting award, that has to be read into this, and that could supply the reasons.
That has supplied the reasons.
No, he was informed on the same day, definitely is relevant of the original award.
Yes. Then, my lord, there is arekta Delhi judgment. Acha?
We want to deal with the Delhi judgments first, and then
Oh,
come to
sorry.
Maharashtra, and then come to Calcutta. In order of importance in commercial matters, Mr. Chairman.
Mahanagar Telecom, na?
Yes.
Yes.
Now Delhi has overtaken Maharashtra, so
Yeah.
Mr. Shen is dealing with the Delhi judgments first, then Maharashtra, and then
Actually, the way I have just
No.
scribbled
you're
it.
just joking. Sir.
Page 52, my lord.
Yes, page 52.
And,
This is DRJ, that Mahanagar.
sorry, yes, my lord, 51.
Right. Yes, Mahanagar Telephone Limited.
Yes, kindly come to paragraph 10.
Paragraph 10, yes.
Here, my lord, the difficulty was there was no clarity on which is the actual award. Lordship will get that. Kindly see.
So-called award of the majority does not contain the date also.
Kindly see paragraph 15
Achha.
at page 61.
Yes.
In the cases hand as noticed at the threshold, the so-called majority award is an undated award. And it does not give out any reasons for omitted signature of the third arbitrator. Non-dating of the award by the two arbitrators does not appear to be due to any inadvertence or for the reason suggested by Mr. Jaitley that the third arbitrator had not rendered his award by the date the two arbitrators made their award. Rather, it appears for the reasons which are not difficult to understand. From a perusal of the record of the arbiter brought on record and the correspondent notes exchanged among them, it would appear that even though Justice Kania, Justice Khanna were not clear as on what date the document said to be termed as a majority award was signed by the two members, letter of Justice Kania dated 12 September address which would indicate that both of them signed the award on 27th August 2000. It is pertinent to note before the said date, the Khanna has written to Justice on 25th August in regard to the note clearly saying he deemed the document as a proposed award. So the confusion was even the majority award was not signed. So the document itself was under doubt. Which is the majority award? That was the question. Then there is unreported, na? No, it had.
Yes.
Full 67. What we wanted to show. Oh, that's your. And 18 Calcutta এগুলো ওদের ওটা দরকার
Mr. Shen, before taking the next judgment, and take that break and come, and we'll start from the next judgment. Yes, Mr.
Then their judgment at page 38 of the compilation.
Yes, Abu Hamid Zahia.
Yes. Here, my lord, middle of the page 38, kindly see the objection was there was no valid award in law because two of the arbitrators had not attended all the sittings. And one at least did not take part in the final deliberation.
Which is not true in your case.
Not. Then, my lord, there is page 41 of the compilation. Maharashtra State Electricity Distribution Company Limited
Yes.
versus Deltron. Kindly come to paragraph 6 at page 46.
Yes, 46.
Here it is also same. Did not arbitrator. If one has regard to the impugned award in the present case, what transpires in the first place is that there is nothing in the award or the subsequent orders of the tribunal council to indicate that the chairman of the tribunal was available and actually participated in the deliberations of the council for making the award. So that is why his signature was not there. There was a remark that he was transferred. So that cannot be a reason because he has not participated at all in the deliberations. Then there is a Gujarat. Page 82. Na? Then there is a judgment, my lord.
SCC Online Gujarat.
Yes.
NHAI.
Yes. 2021 SCC Online Gujarat 3179.
Yes.
But here I find, my lord, this is a case. This is the case, paragraph 18. They said that the arbitral award has not been signed by the arbitrator. It is not a case of a tribunal.
Single arbitrator.
Single arbitrator, signature was not there. Kindly come to the factual aspect also. There also it is recorded. Kindly see page 68, paragraph 2 at 67.
Yes.
Paragraph 2, my lord, they have given a quote at paragraph 68, top. The impugned final order, operative order reads as under. Application is partly allowed then. The award and order dated such and such passed by subdivisional magistrate Anjar and award and order dated passed in NH award case number such and such by arbitrator, collector, Kutch are hereby quashed and set aside.
Starts at page 73. Page 74, collector is appointed.
The only arbitrator did not sign the award.
That is what I find.
He signed as the
Why so many
I think he signed as in his administrative capacity as collector. There is a list of dates which they have quoted in this judgment.
Page 73.
73.
The entry
at page 74, your lordship will come.
2030. Appointed as arbitrator.
Yes.
Collector is appointed as arbitrator.
Well, the second last date on that page.
Yes.
It is pertinent to in that box, my lord. It is pertinent to note that collector is appointed by the central government as arbitrator. Then, my lord, 10th July 2018 date, award passed by the arbitrator in Lawad case number such and such. Then in that box, your lordship will read. It is pertinent, therefore, order passed by the arbitrator stroke collector is ex facie illegal and against evidence on record. It is pertinent to note as per section 31(5), award ought to have been signed as arbitrator, but in the present case, award has been signed by the chitnish to collector and not by the arbitrator, and therefore the same is patently defective.
Chief means some subordinate official.
Subordinate official.
Very good.
So this is on a different footing altogether. OPG. But just for completeness, on 34 principle, I'll just cite OPG, which has considered the earlier judgments, which we have already placed.
Associate and Sangyang has been cited by Mr. Chinda. Those cover everything.
Everything.
Those are
Right.
omnibus.
All parties rely upon that.
Yes, either this paragraph or that. You'll find something there for everybody. This is OPG. Yes.
OPG paragraph 74. And Sangyong and everything has been considered here, including
As I often say, Mr. This is like a memory game. So I say 1, 2, you say 1, 2, 3, and then we add on and give all the judgments, and the last judgment contains all of the previous ones.
These are, I shouldn't say,
Becoming a memory
these
game.
are like research papers.
These are research papers. These are like means these are research papers.
For a new subject, it is you'll get just at the click.
What do you mean to say that? To the judges, these are new subjects?
No, for us, we dare not say anything.
So if it's a research paper by the judge, then it has to be a new subject to the judge.
Now, if I am not abreast on one particular subject I have not read, if I find out the latest judgment on that subject, I can go through everything and just make myself conversant.
I am just careful to be below the threshold level of impeachment. Below that, you can say whatever you like. Very good. 74, why are you relying, Mr. Shen?
No, 74 is just
the general statement, yes.
General statement. Then 75 onwards, I am not relying that part because those relate to reason. We are not concerned with the reason part.
So this arbitrator is the ultimate master of the quantity and quality of evidence. Basic. Yes.
Possible view by arbitrator on facts is to be respected.
Who will say
category that a perverse that on an error of fact an arbitral law may be set aside. Mere erroneous application of law or wrong application of evidence by itself is not a ground. And my lord, paragraph 84 with regard to interpretation of a contract. In a
Yes,
an arbitral tribunal must decide in accordance with the terms of the contract. In a case when an arbitral tribunal passes an award against the terms of the contract, it would be illegal. However, arbitral tribunal has jurisdiction to interpret a contract having regard to terms and conditions, conduct of the parties, including correspondence, circumstances, and pleadings. If conclusion of the arbitrator is based on a possible view, the court should not interfere. But we're on full reading of the contract view of the arbitral tribunal.
But there are certain judgments, Mr. Shen, which also say the interpretation is not in consonance with the contract, and which takes you to square one. But
then
even then,
again, the first appeal, like
yes, back to square one. But yes, we this is the apparently the right view, because if it's a possible view on anything, you cannot. Interpretation of contract,
not a view that no reasonable person.
Absurd, unconscionable, shocking,
yes,
or at least patently not in consonance with the contract, then we can say.
I think these are my suggestions.
Thank you.
We will file a note after.
Yes, we will take notes after Mr. Chinda. No, I can't say Mr. Chinda. Mr. Chinda, would you like to give your reply? Any further reply?
I would just want one date for the reply, because the arguments have spanned over 3 days.
Yes, absolutely. Very good.
We need to just
collate
everything. Collate everything, put it in one place. We would also on the next occasion actually come with our notes.
Yes.
So that it's easier for the Honorable Court to.
Very well. Then I'll express that in my judgment, in my today's order, that both of you will file your written notes on the next day. Reply, you cannot have a new right, Mr. Shen. You'll prepare your written notes.
Friday, they will be busy in Holi. Who
would be busy in Holi?
So not this Friday, of course. It will have to be.
Then it is fine.
6 March, you have difficulty. 6 March. 6 March is after.
It's immediately. Yes. It's immediately after Holi. Could I request for 13th, Manoj?
Yes. Very well. 13th. Heard learned senior counsel appearing for the respondent. Full stop, next para. for commencement of the reply of the petitioner, comma, let the matter stand over till March 13, 2026. Full stop. The parties are requested to, the learned counsel for the parties are requested to file their written notes of arguments on the returnable date. Thank you very much.
I'm obliged, my lords. I'm obliged.
Thank you, sir. Thank you. Alternatively দেখানো থাকবে ওই অনেকদিন আগে থেকে কিছু নেই কুচলে এখন যে কোনো আরবিট্রেশন যখন ম্যাটার নেবো না তুমি এটা দিয়ে রাখবে কারণ ওরা রেফার করবেই কেন Yes, Mr. Bodhe.
It's a substitution application, Lordship.
Within time?
Within time, not within a Lordship. Perhaps
Not within time?
delay is there, but it's a
You have served a copy on this?
Lordship. I'm sorry.
You have served?
Yes. To the state of West Bengal.
Achha. So you just file your receipt regarding service also. You have.
We have a Lordship there. It's already filed with the.
It's all the receipt আছে কোনো আগে affidavit of service or receipt?
I have a Xerox.
This affidavit of service?
Lordship, this is we have filed the along with the application. Application is there, Lordship.
GA3.
Substitution application. Yes.
GA3 is a substitution. Yes, yes. Yes, yes, sir. Right. So, what is the delay, Mr.
The expiry is on.
Yes.
Annexure 30th August, Lordship.
Who has expired?
One of the petitioner, Lordship.
One of the petitioner.
Proforma respondent, Lordship.
Achha. Proforma respondent number
7, Lordship.
Amit Kumar Rai.
Lordship. He is no prayer has been made though.
When did he expire?
On 20th August, Lordship. 30th August.
30th August, and you have filed this application in January.
December, Lordship. We have.
Oh, no.
24th December, we have filed it, Lordship. September, October.
No. এই ডেটেরটাই তো ফাইলিং ডেট এটাই একই ডেট থাকে এখানে No, it was affirmed probably on that date, but 13th of January it was filed.
It was actually that was the last day of the after that scrutiny. Then they gave the number. On 24th of December, it was affirmed and filed, but after the scrutiny, they have given this number. So they took it on the day it was.
So approximate delay is about say 90 days means
around 30 days around.
30 days. What any reason you have given here? So it is not even delayed.
Subsequently, that is why it was delayed actually. And he is a pro forma Lordship, so
despite service, none appears on behalf of the respondents at the time of call. Full stop. The affidavit of service is already on record. Full stop. Next para. The present application is for substitution of the heirs and legal representatives of the deceased pro forma respondent number 7, Amit Kumar Rai, who died on August 30, 2025. Full stop. Next para. Upon perusal of the averments made in the application, comma, the court is satisfied that sufficient explanation for the delay in preferring the application beyond the limitation period of 90 days has been furnished. Full stop. Next para. You have not given the particulars of the
Lordship, it is there, Lordship.
In the cost
it is annexed to the annexure X, Lordship. Page Lordship will come to page 17, Lordship.
You have just stated that in the application itself.
Actually, in original side, Lordship, the annexure X has to be there in need case.
No, even in the application, annexure X is there. That is the proposed amendment. But in the body, you have to, on oath, you have to state.
Lordship.
Major sui judice you have stated.
Lordship, in para 4, it is stated, Lordship. We have stated in para 4. I indicated in here, Lordship.
So from the averments, comma, na ki bolam? Next para. From the averments in the application, comma, it transpires that the proposed that among the proposed substituted pro forma respondents, comma, proposed substituted pro forma respondents, comma, Srimati Moumita Roy, comma, the widow of the deceased, is major and sui juris, whereas the minor daughter, namely Urchita Rai, is still a minor and is represented by her mother, Srimati Moumita Roy. Accordingly, GA3 of 2020. Accordingly, GA3 of 2026 is allowed, comma, thereby directing the substitution of the heirs and legal representatives of the deceased respondent, deceased pro forma respondent number 7, late Amit Kumar Rai, comma, in terms of the particulars as mentioned in annexure X, comma, at page 14 of the present application, after setting aside the abatement. Full stop. Next para. The office shall carry out the necessary corrections in that regard to the cause title of the writ petition within a fortnight from date. Full stop. No address to court. Deeply obliged. Thank you. Returnable substitution dialogue. Deeply. Would you, the writ petition itself has been assigned to this court, Mr.
Lodge.
The matter shall next be listed in the monthly list. The writ petition shall be listed in the monthly list of April 2026.
Deeply obliged.
Please, Your Lordship.
Yes, Mr.
Unfortunately, this is the third round in the same writ petition. My lords, kindly have Your Lordship's order of 21st March 2022, please.
2022.
21st March 2022. Troubling Your Lordship.
No question of trouble.
Lordship, may I hand over?
Yes.
Because this is the genesis, that is why I was. So-and-so argues that despite pendency of an application of the petitioner which had been operating at the relevant period as a non-banking financial company, seeking consent for the petitioner's amalgamation, the respondent authorities cancel the license or registration of the petitioner to function as an NBFC by an order dated so-and-so, which order was affirmed in appeal. It is argued that the only allegation of the respondent authorities was that the petitioner had not furnished all documents which were asked by the respondent authorities in respect of such. However, submitted all such documents were furnished. Then, my lord, kindly come to the next paragraph. Although learned counsel appearing for the RBI controverts the allegations made by the learned so-and-so appearing for the petitioner, insofar as the production of all documents of petitioner at any point in time is concerned, learned counsel agrees on principle to the suggestion made by the learned senior advocate appearing for the to ensure proper and complete disposal of this. The outcome of the present writ petition shall obviously depend somewhat on the result of the application for amalgamation of the petitioner, which is pending since August 13, 2014. That is from much prior to the cancellation of the petitioner's license or registration as NBFC. Respondent authorities are directed to decide the application filed by the petitioner for consent of RBI application, which was filed on so-and-so in accordance with law as on that date. Well, the point here was that I applied for amalgamation with another entity, which would increase my capital base beyond the minimum requirement of the RBI. RBI does not decide my amalgamation application, but because my capital base is not there, sufficiency of funds on that ground cancels my registration. So, my lords directed the RBI to pass a reasoned order. This is the round. Now, my lord, kindly see the next order, which is dated 20th December 2022. In between, there was an order dated 1st July 2022, passed by the RBI rejecting my application for consent. Now, kindly see the next order passed by your lordship, 20th December 2022.
22nd.
20th
December 2020, yes.
Yes.
That is only on the.
My lord, I have put it in the supplementary, kindly. Reply to supplementary. Kindly see.
December is only adjournment.
I'm sorry, that was a separate writ. I'm sorry, that was a separate.
Oh.
This 20th December 2022, page
Please.
19, please. Page
In-
19.
Yes.
Now, this order of 1st July 2022, which was considered by your lordship in this order, was the order made pursuant to the earlier order of March.
This was on the amalgamation application.
Yes.
Right.
Now, on considering the amalgamation application. Now, 1st July, so this order was made by the Reserve Bank, rejecting my amalgamation application, which was assailed before your lordship.
All right.
Present challenge has been preferred against an order dated so-and-so, that is 1st July, passed by RBI, rejecting the application of the petitioner company for grant of no objection to a proposed scheme of amalgamation. At the outset, upon commencing hearing in the matter, it transpires
Decide. Remanded.
remanded.
After that, decided.
Again rejected.
I mean, what is that?
That
Now
is,
you're
my lord.
challenging that now.
Now I'm challenging that, my lord. 21st June 2023, page 173 of the supplementary affidavit.
Yes.
The first page, my lord, records the events up to the date,
Previous, yes.
previous events.
Right.
Now kindly turn to the next page. In compliance of the directions of the Honorable High Court, the RBI granted an opportunity for hearing to the applicant company on such and such date in which so-and-so all these were represented. Applicant submitted the latest financial statement of all the companies involved in the proposed scheme of amalgamation and other related documents for ascertaining the current and post-merger financial position of the company. On a careful examination of the submissions, the following issues up. The applicant company applied for consent for the scheme of amalgamation on August 11, 2014. Net owned fund criteria in terms of section so-and-so was not adhered to by the applicant company since financial year of 2012-13, and the NOF of the company has been gradually deteriorating. The company has not attained the NOF of 200 lakh rupees as specified by the notification dated March 27, 2015. This is what your lordship observed prior in the first order, that this notification, my application predates the requirement of 200 lakhs. The applicant company was repeatedly requested by RBI on different occasions to achieve minimum NOF-wide letters. Kindly note the date of the letters, my lord. Not one letter is before 2014. May of 2015, June of 2015, November 28, 2016, March 8, 2017, and August 4, 2017, as it failed to comply with the statutory requirements of maintenance of required NOF. There were other supervisory concerns, that is non-submission.
Mr. Thakkar, do you say that the relevant date should be August 11, 2014? On that
No, my lord,
date,
if my application of, if the August 11, 2014 amalgamation is allowed or rejected,
so that should be the relevant
that
date.
is the relevant date.
Up to that date, whether you had maintained whatever.
I had the NOF. Now, my lord, and this also, my lord, March 27, 2015 NOF also I will meet if my amalgamation is allowed.
No, it is also recorded that in financial year 2012-2013, which is prior,
Yes.
you had not adhered to.
No, my lord, this is without any this is just a vague allegation without finding, because that NOF, how I have not met, there is no reasoning. That NOF was always there.
Very well.
That NOF was always there. Otherwise, my lord, your lordship would have seen there would be at least one notice. When he refers to all the notices in II, saying that you've not met the NOF, then there would be at least one notice given to me. There's not reference to even one notice. NOF may be deteriorating, but that does not mean that it does not meet the criteria. The criteria is for example, the criteria is 500.
Yes.
My NOF is 600. It deteriorates from 600 to 530. I am still within limit. This is just
That is not what they're saying. You did not attain the NOF of
was not adhered to.
No, the last sentence of I is the company has not attained the NOF of 200 lakh rupee.
Yes,
that is
correct. That is correct. But that NOF criteria comes in 2015.
Yes.
If my amalgamation of 2014 is considered, the company with which I am amalgamating has much more than this 200 lakhs.
All right.
That is where the issue is, Mala. They do not consider my amalgamation application and cancel my registration on the ground of not having NOF. So the NOF would have been achieved if my amalgamation
So
is
everything else is subsequent. They take note of subsequent
Yes.
events, and 2012-13, which is the only prior, they give no reasons.
They give no reasons. And your lordship's first order was that it is an unreasoned order. Then kindly see, there were certain supervisory concerns. There are other certain so-and-so non-submission details of directors by the company even after. In this connection, some letters by the company were undelivered, returned back. Some remained unreplied and some were partially replied. These letters I'll show you, but this is not his reason for rejecting. Further, the applicant company, with a letter dated so-and-so, submitted further documents. Now kindly see, madam, on analysis of the financial statements of these companies for the financial year 13-14 and 21-22, which indicate that all 5 proposed transferor companies are doing non-banking financial institution activity without obtaining certificate of registration from RBI in violation of extant guidelines of RBI. So they say that the transferor companies are doing this business without having obtained the certificate of registration from RBI in violation of guidelines of RBI. Well, again, no reasons. Finding without reasons.
No, the reason is that they don't have the certificates of registration.
My lord, but the
That is
actual
sufficient reason.
no, my lord, the actual finding is what is the NBFI activity. From the balance sheet, you are saying this is the
components.
conclusion. This
Only if they have that activity, only then the.
then this conclusion comes.
Well,
And I'll trouble your lordship with the balance sheets, my lord. This is a conclusion.
yes.
Or this is another ingredient to come to the conclusion. There have to be 2 ingredients.
Right.
One is the offense, and then in the charging section. There is no offense. The charging section is applied. In terms of 45(1)(a) of 45(ia) of the Act, no company can commence or carry on the business of an NBFI without the COR issued by the RBI. It is clear from the above that all the 5 companies which have been proposed to be amalgamated with the applicant company are engaged in NBFI activities without having COR from RBI. Further, under the RBI Act, attainment of NIF. Now, this is the additional ground. Further, from the RBI Act, attainment of NOF is also a condition which has to be satisfied by a company before it can commence or carry on the business of an NBFI. In the instant case, the applicant company has not attained the required NOF and therefore it is not competent to carry on the business of an NBFI, which is also a requirement under the RBI Act. Well, this is a repetition of what was said
The
earlier.
previous one, yes.
This is the previous one. But he has to assess on as on 14. Then, Malad, kindly see when, Malad, if on 14 I did not meet the requirement, then the question of cancel, my applying for his consent to amalgamate would not arise. Then, Malad, I would have been struck off in 2014 itself. That you do not require my consent and I'm striking you off now because you don't have the NOF. They keep my application for amalgamation pending. By a subsequent event of 2015, they say you've not attained NOF. If I have not attained NOF, then, my lord, the question of my seeking his consent doesn't arise. Kindly see the catch 22.
You are right on that, Mr. Thakkar, but they have to take the considerations of 2014. When
2014.
But even as of today, I mean, when they grant you this thing, they permit your amalgamation. Don't you have to recover with today's compliances also?
We will meet 200. We'll be much more than 200. Much more. Well, the issue is, what your lordship's order was that please give a reasoned order as to why his sanction for amalgamation has been declined. That is the only issue.
But they'll give that sanction only today.
They'll give it
although you had applied in 2014.
2014.
So today's compliances you also have to, I mean.
No, my lord, may I just, that might be with the greatest of respect, my lord, deciding a subsequent event. The sanction for amalgamation has nothing to do with whether I comply with NOF or not.
Right. Amalgamation would have happened in 2014 itself.
Amalgamation happens in 2014. Now I'm amalgamated.
It's not a continuing cause of action sort of thing.
My lord, once
it's a one-time amalgamation.
It's a one-time amalgamation. Now, my lord, I amalgamate with say 3 companies, my lord. And with my net.
Then if you meet the requirements, then
I'm through. But I don't meet the requirement, I'm out. In spite of amalgamation, if I don't meet the requirement, that's a subsequent matter which is not the subject matter.
It will be a subsequent cause of action.
That is a
for them to cancel.
For them to cancel. But they, with the greatest of respect, put the cart before the horse. And, my lord, now kindly see the apropos this, that you are carrying on business with 5 proposed transfer companies who are doing NBFI activity.
What sort of NBI? No, not.
What sort? Number 1. Number 2, then the Act authorizes them, or rather casts a duty, statutory duty upon the RBI to stop all those 5 companies from acting as NBFI. That is the statutory duty. That is why the RBI is there as the regulator and the non-banking. And that is why all these sections are there in the RBI Act, that if somebody is doing a non-banking financial institution activity, the RBI will stop it.
No step has been taken.
No step has been taken. That now, that cannot be a ground for not granting me sanction to amalgamate. They are naughty boys. You don't want me to amalgamate with naughty boys. You take action in naughty boys, nothing. And if I amalgamate with somebody who's naughty, my license will get cancelled. that you are amalgamating with somebody. Now we amalgamate, but your license. Well, the test is what is the rationale for rejecting my amalgamation application. That has to be the, with the greatest of respect, the decision which your lordship wanted on reasons. Give a reasoned decision as to why you will not give him permission to amalgamate. And there's with the greatest of respect, nothing here, Malad. Then kindly see the next paragraph 5. It is relevant to observe that sanction of amalgamation of a company is to be obtained under the Companies Act, and that the requirement under the directions issued by RBI is limited to taking its approval for prior approval before seeking sanction under the Companies Act, which is applicable to those companies which are otherwise legally competent and carrying on such business under the RBI. This is absolutely correct. Whether I will get sanctioned to ultimately whether my application for amalgamation will be allowed by the NCLT or not, that is for the NCLT to decide. But because I'm carrying on this particular line of business, the RBI rules and directives cast an obligation upon me to get a prior sanction even to apply. I have to apply, but without his sanction, I cannot apply. So this is correct. As the applicant, now Malad kindly see, as the applicant company is not competent to carry on the business in question under the RBI Act due to lack of NOF, and also due to cancellation of COR, which is subject to the orders of the High Court in the pending writ petition, and as all the companies are already carrying on such business in violation of RBI as discussed above, there's no discussion. RBI is of the considered view that no such prior approval requires to be provided for the purpose of amalgamation. So, NOF and cancellation subject matter of writ. The COR is cancelled because of lack of NOF. In 2014, there was no lack of NOF. NOF lack is coming in 2015. So, a subsequent event cannot be a ground for rejecting my application on a prior date. And as far as this, as discussed above, there's no discussion. This is if say Dixit. A finding is written that you're carrying on business of this.
Now, if it is allowed today, Mr.
Yes.
Thakkar, your amalgamation will happen today.
My amalgamation will also not happen. I will only get permission to apply for amalgamation before the NCLT. And that will take about 3 months, 6 months, whatever time it takes.
But it will not relate back to 2014, date of application.
It will take, because the specified date is there, Malad. The amalgamation order always relates back to a specified date to which it relates back. Now, Malad, once the amalgamation is done today, I have to meet the NOF. I'm not challenging the criteria prescribed, nor am I saying that I'm not liable.
Current criteria also have to be met.
Current criteria.
You say that will be met if you
Yes, if
amalgamate.
it's not met, that is not the great, not this. I am not inviting your lordship to grant me any protection. Read the applicability of the current criteria.
Right.
I am only humbly praying that kindly grant me permission to amalgamate. That is subject to final order of NCLT. Once I amalgamate and your
amalgamation has retrospective effect from 2014.
Yes, no, my lord. I cannot say that it has or does not have, but in the scheme, I can always provide it has retrospective effect, because amalgamation orders are always with retrospective effect. And I need not, with the greatest of respect, my lord, even go back to 2014. I go back till 2015 when this comes. When the NOF comes, if I say it is with retrospective effect from 2015, I meet the NOF right away.
All right.
The major trouble, your lordship, once with the prior decision which was made, which was set aside by your lordship and the matter remanded. Kindly see the prior decision, because that will also throw some light, my lord, as to what your lordship wanted them to do, but they did not do. That is, my lord, page 68 of the supplementary. 1st July 22, which was directed to be reheard. Kindly come to 68. The same reasons, my lord, have been repeated. 68, kindly have. This was the prior order.
Yes.
If your lordship sees the cause title, if I may say, my lord, in the matter of an order passed by the Honorable High Court on 21st March 22.
Still, previously there was an order.
21st March 22 was your lordship's first order to pass a reasoned order. Now, this is the so-called reasoned order, which comes. Now, kindly come to the next page.
Now, this was again set aside by me.
This was set aside by your lordship on the ground of lack of reasons. Now, kindly see paragraph 4.
Yes.
That on careful examination of the submissions made by the petitioner company, we observe as follows. The company engaged in the business of NBFC activities and had to obtain a minimum net owned fund in terms of section 45 IA. Minimum net owned fund, kindly see, my lord, Minimum net owned fund was 25 lakhs as per the existing directions at the relevant point of time. So that is in 2014, it was 25 lakhs. The company did not adhere to minimum NOF since the financial year 12-13. NOF was gradually deteriorating. Company applied for NOC for the scheme of amalgamation on August 11, 2014. Company was advised to file. Company has repeatedly was advised repeatedly to achieve minimum NOF VDR letters dated so and so, which your lordship sees in the next order also. Now it is 200 lakhs. Meanwhile, the company changed its management without prior approval. This is not a ground which is now taken here. There were other supervisory concerns, that is non-submission of so and so, even after repeated. This is again here. In this connection, some letters issued by the company, those remain undelivered. Verbatim order. That in the meanwhile, RBI notification came in of 27 March 2015, minimum NOF. Company failure to achieve the specified NOF is in violation of the conditions subject to which the company was permitted to carry on the business of a non-banking financial institution. Same amounts to violation. COR issued to so and so is accordingly. Now this is where it is cancelled. For failure to achieve NOF of 200 lakhs.
So the amalgamation criteria, the NOF criteria and all, they have to relate back to the date of the application.
To my date of my
On that date, whether you are eligible.
Yes.
Correct.
In view of the above, has not met and does not consider to appropriate grant of objection to the proposed scheme. Now, kindly see the incongruity in the order. If my COR is cancelled, then I don't need any prior permission for him to amalgamate. I need the permission to amalgamate because I am liable to comply with his directions because I have a COR. My COR is cancelled. There's no question of him rejecting. He just has to say it's not. Now, this is the order which your lordship was pleased to hold by your lordship's order of 20th December 22, that it is wholly unreasoned. Again, no reasons as to why amalgamation should not happen.
Yes, Mr. Kundu.
There are series of information in this matter. My lord, your lordship's order kindly come to pay dated 20th December 22. My lord, that your lordship will find page 71 of the supplementary affidavit.
Yes, please.
My lord, the present challenge has been preferred against an order dated July 1, 2022, passed by the Reserve Bank of India, rejecting the application of the petitioner company for grant of no objection to a proposed scheme of amalgamation and merger of the company. That is the subject matter. At the outset, upon commencing hearing in the matter, it transfers that the said order is palpably devoid of detailed reasons. Now, my lord, next page, the Reserve Bank of India, while passing the said, did not adhere to all the materials consideration. Lord, in such view of the matter, instead of going into a lengthy hearing of the matter, WPO 2544 of 2022 is disposed of by directing the Reserve Bank of India to hear the matter afresh and to redecide on the application of the petitioner for grant of no objection to the proposed scheme of amalgamation and merger. Now, my lord, here your lordship has given the Reserve Bank of India to redecide the matter afresh. All right, in compliance with the paid, my lord, order, my lord, we have, my lord, considered afresh. Now, my lord, your lordship will find that from page 173, that is the order passed on 21st July 2023. Now, your lordship will kindly come to in the supplementary affidavit filed by my client. Now, Lord, we have filed also a counter to that supplementary affidavit. We have given the reasons. My lord, may I read it out, my lord? Your lordship will kindly come to the affidavit on behalf of respondents affirmed by Siddhartha Shankar Rai Chaudhary on 25th day of April 2024. Kindly.
এটা কোথায়? এগুলো?
My lord,
Yes.
we have given the entire thing in this affidavit to their, I mean the supplementary affidavit. My lord will kindly, may I read it out, my lord? My lord, kindly come to page 5, paragraph 5.
Yes.
Petitioner company had filed an application dated August 13, 2014 for prior consent of the RBI for a proposed merger of that company with with 5 other companies, namely such and such. The petitioner company had submitted inter alia certain financial statements, a perusal of which indicated that it was not having the specified NOA of rupees 25 lakhs at that point of time. The petitioner company was repeatedly requested by RBI on different occasions to furnish certain information and documents as required pertaining to non-compliance of statutory requirements, including non-adherence to the prescribed limit of NOA and pertaining to company
But this
request
is-
for
this
change
is-
of management.
This, Mr. Kundu, these things you have not mentioned in your order, that they did not comply at the relevant point of time, this 25 lakh.
My lord, this is not mentioned.
Then Mohinder Singh Gill hits
We
you.
have, my lord, in view of your lordship's order, we have considered the matter afresh.
No, Mr. Kundu, no doubt on that. You have considered and you have passed a reason order. We are not in doubt of that. But these reason, this is the new reason which is not there in your impugned order.
Not there.
So then you are hit by Mohinder Singh Gill's principle. You cannot improve your case by way of affidavit.
That is there. That is there.
You
my
know
lord.
better than
But
us.
only thing, my lord, your lordship will kindly consider this thing. My lord, it is,
So this ground cannot be looked at.
my lord,
Is-
only it is that, my lord, the RBI has considered
Yes.
that the other companies' financial statement they have submitted. Now, my lord, we have at the same time, my lord, kindly come to annexure R1 of this affidavit. The financial position of the company we have stated since 2011-12.
This is which company?
This Nadia petitioner company.
Acha, acha.
My lord, they, my lord, were, my lord, from the year 2011-12, NOF was going on minus all along up to 2017-18.
No, but this is squarely violative of
That
Mohinder
is-
Singh Gill.
That
You are
is not.
furnishing new reasons to your order.
That is there. My
You
lord.
are right, Mr. Kundu, at least regarding 2012-13 and 13-14, maybe German. Because that is prior to the date of the application even. Absolutely. But these are not there in your, they could not
My lord, this was not
deal
there,
with this.
but in the affidavit it is stated.
You
my lord.
tell me. You advise the court. Mr. Kundu, you are a sufficiently senior person.
May I?
Can we do
lordship
this?
will kindly make an observation and direct the RBI to reconsider the matter. This is.
These are new grounds. Actually.
My lord,
If these grounds are there, you may have a point. Then they were not in.
That is not there.
We'll set aside this impugned order on 2 or 3 grounds. I am telling you this because so that you can. One is that regarding 2012-2013, the particulars are not given, which you have given here. You are hit by Mohinder Singh Gill. Therefore, we are relegating you back. But regarding the other 5 companies, the transferor companies, Mr. Kundu, you have to satisfy the court as to whether their non-compliances is germane for the consideration of his amalgamation application. Is it germane at all? As Mr. Thakkar nicely put it, I mean, naughtily put it, that they are naughty boys. But can you prevent your son from joining them, the naughty boys? Once he becomes a naughty boy, you can slap him.
That is why, my lord.
You are not slapping physically, slap a cancellation of his.
That is why I am submitting, my lord.
So naughty boys,
Consider.
you take steps against those 5 companies, but
observe in the order.
So that it will provide some guideline to the order also. Mr. Thakkar, yes, you have to set aside this and send back. These are new grounds. If these grounds were actually there, then you were not entitled even in 2014.
My lord, these.
We'll give a timeline.
My lord, let them. I'll tell you, this will now be the 3rd round. My lord, 1 decade has gone.
I anticipate a
2014.
fourth ground also because Mr. Kundu will not be there when the order is passed.
Look, kindly keep this matter pending, because that is how your lordship has, this matter has been kept pending. Orders of court have not.
If I keep this matter pending, then we cannot ask a re-adjudication.
No, that is what was done in the last case, my lord. The order was set aside.
If I did it, it was wrongly done.
No.
Someone else did it, probably, I mean.
No, my lord, there are more prayers in the writ, my lord, other than this. Because everything, my lord, my COR has been cancelled because of this NOF.
Yes.
That is the main relief.
But every time if the site news grounds, and these grounds, Mr. Thakkar, if you did not comply even prior to 2014.
No, my lord, these grounds, these are the reading of my balance sheet, which I can explain to them that this reading is incorrect. This how he
that
comes.
That is precisely what we are asking them to do.
Correct.
I mean, they have to cite judgments.
And my lord, the other thing is that if your lordship is inclined at all to remind it back, then my lord, they should give me a questionnaire. Because every time I go for a hearing, they ask me 3 things. I answer those 3 things.
Like a show cause.
Like a show cause. Then I can give a point-wise. Kindly
give them the time-bound program.
My lord, may I just show your lordship? My lord, let them. My attorney is very confident. My attorney is very confident that if your lordship, we will
restrict them to these grounds.
No, my lord, we will give the balance sheet to my learned senior friend, and we will produce the balance sheet in court also. Only keep it next Friday. It will be palpably demonstrated that these findings are incorrect. Even if your lordship is pleased to go into this new ground, even if, because my lord, my functioning is now stopped. I don't have the NOF. My business has come to a standstill for 10 years. That is
fully appreciated. Yes.
10 years now, my lord, more than 10 years now, my business is held up. All that I am seeking is a sanction to amalgamate.
Mr. Thakkar, I'll permit you to file a supplementary affidavit annexing all your balance sheet for relevant period and relevant pleadings to deal with these. I'll prima facie observe that post facto after 2014 alleged non-compliances cannot be taken into consideration. I'll prima facie observe because I'm keeping the matter pending.
Prima facie.
Mr. Kundu, just to cut short the matter there, the COR is pending. It has been cancelled, in fact, not pending. And the other aspect, NBFI with COR, their non-compliances cannot be a ground for rejecting his amalgamation. That also will prima facie. All these will be prima facie, which I'll make absolute at the final hearing. And these.
My lord,
we'll direct them to file supplementary.
Yes,
Friday week.
Friday
week.
Yes. He can also consider. His officers will need some time to consider the balance sheet and give how they support these figures. They will instruct my lord.
We'll put it on 13th. 13th is Friday week.
Yes, my
lord. The present challenge has been preferred against the rejection of an application for amalgamation made by the petitioner number 1 company by the respondent authorities on several grounds. For next para, learned senior counsel appearing for the petitioners submits that none of the grounds attributed in the impugned order are sustainable in law. Since the next para, since the application for amalgamation was filed in the year 2014, the alleged instances of non-fulfillment non-fulfillment of the NOF within bracket net owned fund bracket closed criteria subsequent to the date of the application, that is August 11, 2014, are not germane, since the position as on the date of the application was to be considered for the purpose of adjudication of the amalgamation application. For some next para, learned senior counsel next argues that alleged non-compliances of certain essential preconditions for doing NBFI activity of the 5 transferor companies, with whom the petitioner number 1 seeks to amalgamate, has been cited in the impugned order as one of the grounds for rejection of the application for consent for the purpose of the scheme of amalgamation. However, it is argued that the said consideration is not germane in the context, as even if there were certain non-compliances on the part of the transferor companies, the same would at best permit the RBI to take appropriate legal action against the said companies. Full stop. However, comma, such non-compliances, comma, even if any, comma, would not be relevant for the purpose of consideration of the petitioner's application. Next para. Thirdly, comma, it is argued that certain allegations have been made regarding non-compliances for the financial year 2013-2014, comma, which have not been substantiated by giving particulars thereof in the impugned order. Full stop. Next para. As such, comma, it is contended that the impugned order should be set aside on such ground as well. Full stop. Next para. Learned counsel appearing for the Reserve Bank of India, comma, by placing reliance on the affidavit filed by the respondent authorities within bracket affirmed on April 25, 2024, comma, argues that the petitioner number 1 company had failed to comply with the necessary NOF requirements even prior to the date of the application, that is August 13, 2014, inasmuch as it was not having the specified NOF of rupees 25 lakh. Full stop. Next para. That apart, comma, learned counsel places reliance on annexure R1 of the respondent's aforesaid affidavit to contend that even for the financial years 2011, 2012, 2012-13 and 2013-14, the petitioner number 1 company had not complied with the necessary NOF requirements. Full stop. Thus, comma, learned counsel seeks to justify the impugned order. Full stop. Next para. At the outset, comma, it transpires prima facie that the consideration of alleged non-compliances by the transferor companies is not germane for the purpose of adjudication of the petitioner's application for amalgamation. Full stop. Next para. Thus, the reliance on the same by the respondent authorities was misplaced. Full stop. Next para. Secondly, comma, it is found that the alleged non-compliances by the petitioner number 1 company for the period prior to the application dated August 13, 2014 have not been mentioned in particular in the impugned order, comma, thus vitiating the order as well. Full stop. Next para. Thirdly, comma, certain thirdly, comma, no particulars of alleged non-compliances by the transferor companies have also been furnished in the impugned order. Full stop. Next para. Although the respondent authorities have tried to improve their case by furnishing purported particulars of the non-compliances of the petitioner number 1 company during the period prior to the date of the application, in their affidavit filed in connection with the present petition, comma, it is well settled that a party cannot improve its case at the stage of improve its case by filing affidavits in a proceeding challenging the impugned order which did not comply with the necessary requirements of law. Full stop. Next para. The case of Mohinder Singh Gill, particular to bhule gayi. Do you remember the citation of Mohinder? Can you find out from your
71 हम लोग का निकाला हुआ है तो
the case of Mohinder Singh Gill reported at uni bole deben. Just write it on a piece of paper.
Yes.
Is germane in the above context. Full stop. Next para. At this juncture, comma, learned senior counsel for the petitioners submits on instruction that the petitioners are confident that they have all the records in respect of compliances, comma, even for the period prior to their application for amalgamation, comma, which shall be reflected from their balance sheets and other relevant documents for the concerned period. Full stop. For the concerned documents reflected from the for the concerned period. Full stop. Next para. It is further submitted that the certificate of registration of the petitioner number 1 company stands cancelled, comma, the adjudication on which is dependent upon the fate of the present amalgamation application. Full stop. As such, comma, in order to avoid further remand at the third round of litigation, comma, learned senior counsel suggests that the petitioners be permitted to produce the necessary documents for the satisfaction of the respondent authorities. Full stop. Next para. Such suggestion is acceptable to the court. Full stop. Accordingly, the petitioners are directed to file a supplementary affidavit containing the relevant explanations and documents pertaining to the alleged non-compliances as per the version of the respondents made out in connection with the present petition. Full stop. Such supplementary affidavit shall be filed within a fortnight from date, within a week from date, comma, with an advance copy to the learned advocate on record for the respondents. Full stop. Next para. The respondents are granted leave to use a rejoinder to the same, comma, if deemed necessary, comma, within a week thereafter. Full stop. Next para. Learned counsel appearing for the respondents is requested to take appropriate instructions, comma, on a consideration of the contents of the proposed supplementary affidavit of the petitioners, comma, as to whether the impugned order requires a reconsideration, and the application for approval of the scheme of amalgamation filed by the petitioners can be approved on the basis of the newly furnished documents by the petitioners, comma, on the returnable date. Full stop. The matter shall next be listed on March. Should we keep it on 20th March, Mr. Thakkar? Because you will require 1 week, Mr. Hundu requires 1 week.
20th might be might be Eid.
Eid. So we are putting it on 13th. If you have any difficulty, we'll yes.
20th March.
Eid hote paise, Shukrobar.
Let us keep it on 13th, Mr. Kundu. If you have any difficulty, either of you inform the other side in advance. We can keep it on the returnable date of March 13, 2026. Thank
you. Kindly take on record.
Citation
I've given Mohinder Singh. The may be recorded the original supplementary affidavit and the affidavit in reply are taken, filed by the petitioner.
The original supplementary affidavit and the supplementary affidavit filed by the petitioners be kept under. What have been filed today?
My original supplementary affidavit assailing this order and the reply to his opposition.
Or I've already given the opposition.
The original supplementary affidavit and the reply to the respondent's affidavit, comma, both filed by the petitioners today, comma, be kept on record.
Great.
Order record করেছি ছেড়ে দাও এই অর্ডারই আছে যে অর্ডারটা বলেছি
IAP for the petitioner. This is my contempt application where lordship an appeal is pending.
Fixed on 2nd, my lord. And my lord, the division bench by order dated 17th November has already observed that in the interest of
Keeps it after
fitness of thing, my lord, will adjourn the matter.
How?
Last page, my lord, can you see?
Yeah, I'm not opposing, my lord. In the past also we have.
Oh, that is also there. Yes.
Yes.
Right.
Learned counsel appearing for the alleged contemners submits that the appeal pending against the parent order is. Oh, sorry. That means তোমার নাম কি? প্রথম থেকে বলছি. Learned counsel appearing for the alleged submits that the appeal pending against the parent order, comma, from which the present contempt application arises, comma, is scheduled to be taken up for hearing by the concerned division bench on March 2, 2026. Full stop. Next para. Even otherwise, comma, the division bench taking up the said appeal was pleased to express in its order dated November 17, 2025 that since the appeals are being heard out, comma, the division bench was sure that on a prayer made by the parties before this court, comma, in the fitness of things, comma, This court will adjourn the contempt application till disposal of the two appeals. Full stop, next para. Accordingly, let the application. We are adjourning sine die. Let the
Keeps
contempt
it after
application.
because Malad, now there is a change of determination.
No,
I don't
the
know what
contempt
will
application
happen.
is, be adjourned sine die.
He keeps it after 4 weeks.
No, no.
Thereafter, Malad Lordship may
No,
adjourn
with
itself.
liberty to the parties to mention the same for inclusion in the list as and when the appeals are disposed of finally, because that is
Or-
the request made. The
or-
bench changes, but the
But if
order
they
remains.
don't take any steps, any step in the
Till
appeal,
disposal of the appeals, that is the request of the division bench. We are adjourning till disposal of the appeal.
because
Therefore, we have to
that
adjourn.
division bench was hearing. Now there is a change of determination.
We can't do anything. The order remains binding on us.
It's a request, man.
Sacrosanct.
We are grateful, my lord.
Thank you.
Great.
Yes. Next.
My lord, this is my contempt application. I apologize for not being able
No
to be
difficulty.
physically present.
No difficulty. Yes.
My lord, I'm a little embarrassed to move this application, but we were left with no other option because the respondent has not been complying with Lordship's order and has also been not appearing in the arbitration physically despite the arbitrator requesting them to. Be that as it may, Lordship, this application is Lordship in your Lordship's determination when your Lordship was taking up Section 11 matters had appointed an arbitrator. Thereafter, the respondent had filed a recall application. Lordship had observed that several facts were suppressed, etc. And thereafter, Lordship, if Lordship takes page 37 of my application, Lordship will see Lordship had directed them to pay me 50,000 rupees of costs.
Yes. They
And-
had obtained the Section 11
No,
order.
we had.
We had obtained
You
the
had-
section. Yes, and thereafter they had filed the recall.
Oh, in the
And-
recall. Achha.
Yes, and in the recall, Lordship was pleased to dismiss it and ordered them to pay 50,000 rupees of costs. Lordship, we have written to them also. Thereafter, page
Not paying the costs.
they
Not
have
paying the
not
costs.
paid the costs. Page 64, Lordship will see I had written them an email asking them to comply. There is also a letter, Lordship, I had written at page 38.
This is appearing for the. This is appearing for the first time.
Yes.
First
my
time,
lord.
Lordship.
A prima facie case of willful and deliberate violation of the order dated September 19, 2025, passed in IA number GACOM 1 of 2025 in APCOM 824 of 2024 with IA number GACOM 2 of 2025 in APCOM 824 of 2024 has been made out inasmuch, despite repeated communications in that regard by the present petitioner, the alleged contemner has apparently failed to comply with the direction to pay costs of rupees 50,000 in terms of the said order, to the petitioner. Push up. No, but sorry, but how can the company be a contemner? I mean, you have to name the persons who are in control. Company cannot be sent to jail or say something like that. Yes, company
Yes.
can be, property can be attached, but contempt has to be, you have to name the persons in control of that company. How soon can you do that?
I can do that within a week, Lordship.
The next para. However, at this juncture, it transpires that the respondent in the aforesaid matter, being a corporate entity, has been implemented as the alleged contemner. For next para, leave is accordingly granted to the petitioner to implead the persons in control of the respondent company, persons in control stroke charge of the respondent company as the alleged contemners, for necessary amendments to the cause title of the contempt application shall be effected by the learned advocate on record by the appellant of the petitioner within the course of a week from date. For next para, a copy of such amended contempt application shall be served on the uh, respondent company as well as the newly impleted alleged contemners, indicating that the contempt application shall next be listed on March 27, 2026, comma, when an affidavit of service to that effect shall be filed by the petitioner. So you carry out the corrections within a week as soon as possible,
Certainly,
and then serve a corrected copy on them, indicating
much
that it will appear next on
obliged.
27.
I'll do
Lordship,
so.
Lordship, can it be 1 week after March 27? Because Mr. Bhattacharya is also not available on March 27.
1 week after is a holiday, then April 10, or returnable date, not March 27, April 10, 2026. Thank you.
Much obliged. Much obliged.
Thank you. Yes. Oh, yes. জলপাইগুড়ি টাকা টেকে না তারপর we are taking up the Jalpaiguri matters first. Yes.
My lord, we were for the appellants, my lord.
This is a Jalpaiguri matter, right?
My lord.
Yes.
My lord, page 4.
Review.
My lord, at page 4,
Yes.
para 13, the last line from January 30, 2006. It will be 2026, my lord.
Right. In the order dated January 30, 2026, comma, in paragraph number 13, in connection with RVW 23 of 2025, comma, the date was erroneously mentioned as January 30, comma, 2006 instead of January 30, 2026. Accordingly, the said date be read as January 30, 2026, and this order be deemed to be a part of the order dated January 30, 2026.
Right. Great.
Yes. Yes. What is the nature of
Your Lordship, today the matter was listed before the Honorable Supreme Court. Your Lordship, but the other side had prayed for an adjournment today, and
the
the matter
SLP against the parent order?
parent order.
Parent
Your
order, Your Lordship.
So what, any order has been passed there?
No order has been passed. I have received communication from the advocate on record. It has
He
been
asked for
listed.
time.
Yes, Your Lordship.
Yes, Your Lordship. There was some problem regarding senior advocate who was appearing, was supposed to appear. So he was on
If
his
you
deck.
go on asking for adjournment, we
Lordship,
cannot
it has
solve the
fixed- It has fixed on 11th March.
11th March.
11th
Yeah.
March.
Learned counsel for the parties submit that the special leave petition pending against the parent order has been listed next on will be listed next on March 11, 2026. A communication in that regard is handed over by learned counsel for the alleged contemner. As such, comma, for the sake of propriety, comma, we adjourn the matter. কবে নেক্সট বসবো 20 তারিখ বসবো 28 তারিখ 27 করে দিন
আপনার 11th মার্চ রাখতে হবে
11th মার্চের পরে বলছি 20 না
27th রাখতে হবে
27th ই রাখছি টাইম দিয়ে on March 27, 2026 under the same heading. It will appear next on 27. So the matter will get some time to be taken up by the Supreme Court.
Grateful to Your Lordship.
Thanks. But if you go on taking adjournments there, we'll consider otherwise.
Had given them a peace of mind. They should not employ any kind of.
Thank you. Thank you very much.
Yeah.
Much obliged.
Principal bench.
My lord,
I am for the petitioner, my lord.
Kita বলেছিল
Small correction in the cost title, and it is very unfortunate that the cost title kindly have a look into the cost title which has been corrected on yes the name of the first respondent has been expunged on her death, and
Shobita Datta's name has come in.
Gita Datta's name has started.
No, Gita Datta is already there. Shobita Datta's name was missing in the first degree. That
yes,
has been corrected.
Yes, the daughter's name.
Yes. Correction টা কি হবে?
Shobita Datta alias Sabha.
So the name of Shobita Datta has to come.
Lordship, kindly come to the last but one page.
এটা এখানে আসবে কেন? এটা উপরে যাবে।
Yes.
এটা তো ডিফেন্ডেন্ট নামটা উপরে আসবে।
It should be Somnath Datta and Shobita Datta alias Sabha.
Mr. Dhar, the Shobita Datta is the principal defendant.
Shobita Datta is a principal defendant. As a defendant, he is all originally defendant number 3
right?
and respondent number
And
3.
here Somnath Dotto,
Somnath Dotto is there.
Gita and Somnath are pro forma respondents. Defendants pro forma respondents.
Pro forma respondent. No, initially in suit, my lord, during the pendency of the suit, the Gita Dotto and Somnath Dotto sold their share. It is a specific performance.
So now they
sold
become
their share
pro
to
forma
the
respondents. Yes.
plaintiff. In Shobita Dotto denied. So the decree has been passed against Shobita Dotto, as they have already coincided and they have executed their deed. And Gita Dotto has passed away during the pendency of this appeal. So her name has been expunged. The cost title has been corrected. Cost title of the appeal has been corrected. There is no difficulty in cost title of the appeal. But the decree, the Gita Dotto's name and Somnath Dotto's name has come, but Shobita Dotto's name has not come. But my grievance mainly against the Shobita Dotto.
Obviously, you are right.
Last but one page, my lord.
In the decree,
in my certified copy.
in the decree passed in connection with the present appeal, comma, the name of the principal defendant, Srimati Shobita Dotto alias Saba Haq, HAQE, was erroneously omitted. Push up next para. On the other hand, comma, the names of the pro forma respondents were captioned with the expression double inverted with the dot 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 pro forma respondent stroke defendant, whereas it should be the reverse. Push up next para. Accordingly, the decree passed in the appeal be corrected to the effect that the name of defendant stroke respondent, the name of Srimati Shobita Dotto alias Saba Haq HAQE shall be incorporated as defendant stroke respondent number 1, whereas
respondent number 3, my lord. She should be
defendant should be the main respondent.
No.
Defendant respondent number 3.
Defendant respondent number 3.
Full stop. The caption of the pro forma respondents shall be mentioned as defendants stroke pro forma respondents. Full stop. Let such consequential corrections be effected to the decree by the department in the light of the above observations.
My lord, actually, while the suit was filed, there was no pro forma defendant. There was no pro forma defendant.
1 minute, Mr. Thor. এখানে 1-2 ডিফেন্ডেন্টস pro forma respondents হবে। pro forma respondent ডিফেন্ডেন্ট উল্টো হয়ে যাবে। আর এখানে 3টা ঠিক আছে, এটা যা আছে এটা ঢুকে যাবে। হ্যাঁ, এটাই কারেক্টেড। We have not said pro forma defendant. We said defendant stroke pro forma respondents. Here they are pro forma respondents.
Yes.
Next.
Subsequently, it has been modified. My lord, there is a consequential prayer, my lord.
No further prayer. We have
only to take back the original title deed, which has been exhibited.
That you have to file proper application in the department and take it back on furnishing copies.
No,
not
initially they returned back against a certificate.
No, this is a court of records, Mr. Dhar. You cannot take back otherwise. You have to give an undertaking that has to be done from the department. You follow the proper procedure. We cannot fund that. Yes, next.
May I take back the certificate copy and the copy?
Certificate copy টা ফেরত দিয়ে দাও। যেটা কারেকশন করলাম ওটা থাকবে। হ্যাঁ, আমি যেটা কারেকশন করে দিলাম হাত দিয়ে সেটা থাকবে। দেখে দাও। বুঝতে পারছেন। অরিজিনাল সার্টিফিকেট কপিটা ফেরত দিয়ে দেবো।
ওইটা কারেকশন হয়েছে
এটা কি আছে বলো?
আই এম গ্রেটফুল।
ইস্যু করেছেন, রিপোর্ট কি দিয়েছে?
My
yes, arrest warrant. Let us see what is the report of the office. কোথায় রিপোর্টটা কোনটা? Accordingly, arrest warrant.
That's order 30th January. Deposited the special messenger cost.
Yes.
PTU.
সিগনেচার অ্যারেস্ট ওয়ারেন্ট কি বলছে?
Yes, warrant of
কোথায়? এটা কি বুঝতে পারছি না, কি রিপোর্ট দিয়েছে এটা?
XYZ কোথায় আছে? We have
Or
submitted
duly served and received.
Yes. Correct. To the report, the central disposal. The copies of.
অ্যারেস্ট ওয়ারেন্ট যদি রিসিভ হয়ে থাকে তাহলে এখন হয়তো অ্যারেস্ট করে পুলিশ করলো না কেন?
হ্যাঁ, যদি রিসিভ হয়ে তো করবে। এ তো কেরালা কে আছে তো।
তো করার কি আছে? I don't understand this. The arrest warrant has been served.
Maybe on the concerned local police station. They
Also
haven't
served. Also served.
They haven't gone and executed your lordship's order.
Next content will be against
Okay.
them. No, their commissioner. No, communicate to the commissioner of police. We have to go higher. This is where Kerala.
Lordship will
Justice
consider.
Pen is there. Yes. Anyway, we will go to that level later on.
What a lovely coincidence.
Lovely. ওর পক্ষে lovely না। We find from the report.
Sorry. The district magistrate, your lordship, could consider who can ensure compliance.
The commissioner of police has been. The police will arrest and produce.
Commissioner and ministerial.
Commissioner of police has been intimated. It transpires from the report of the assistant registrar Roman 4 dated February 25, 2026 that pursuant to the direction of this court, warrant of arrest has been duly served and received by the concerned offices of the local police station where the contemner is residing, and has also been communicated to the Commissioner of Police, Kannur, Kerala, and the station house officer, Kathirur Police Station, Kathirur, Kerala. Full stop. Next para. However, today at the time of call, the contemner is not presented in court by the said police authorities. Full stop. Accordingly, the Commissioner of Police, Kannur, Kerala, is directed to ensure that the contemner is positively produced personally in court on the returnable date for the purpose of passing further orders. Full stop. Let this order be communicated immediately by the office of this court to the Commissioner of Police concerned. Full stop. A further report with regard to such service shall be furnished by the office on the returnable date. Full stop. The matter shall next be listed on April 10, 2026 at 2 p.m. Full stop. It is made clear that in the event the contemner is not produced personally on the said date, the Commissioner of Police, Kannur, Kerala shall furnish a report as to the reason for such non-production. Full stop. In default, we shall be constrained to pass necessary orders, if necessary, against the Commissioner of Police, Kannur, Kerala on the returnable date.
Great.
এই অর্ডারটা ইমিডিয়েটলি অফিসে পাঠিয়ে দিয়ে কমিউনিকেট করতে বলবে। A gist of this order shall also be communicated to the concerned Commissioner of Police.
Very good.
বলবে অর্ডারটা কমিউনিকেট যেতে অফিস ইমিডিয়েটলি করে দেয় কমিশনার অফ পুলিশ। No, not you. Yes.
Respondent. Yeah, see.
Item number 3, Your Lordship, I'm appearing for them, being led by Mr. Krishna.
Mr. Thakur, what was the nature of the contempt?
My lord, this is a slightly unusual contempt. The plaintiff obtained an order of status quo. The respondents came up in appeal. My lords were pleased to confirm the order of status quo with certain modifications, nature, character, possession of the premises not to be changed. And my lord, the user, nature, character would imply user also, and that we were to be given ingress, egress. Now, my lord, it is a plaintiff who has obtained this order who has violated this order. This is that mobile towers were there. They refused ingress to the mobile tower personnel. They put on affidavit false. Where's that chart of mine? They put on affidavit a false case that there were never any mobile towers. The mobile tower personnel are continuously writing to us that service in this area is affected. The mobile tower is shut down. They say on affidavit there is no mobile tower. Then, my lord, the premises were apparently leased out to them for doing commercial business, running it as an office. They use it for religious purposes. There's animal sacrifice and they use it for religious purposes. Animal sacrifice, they say, prior to the date of the order, I'm not getting into any controversy in contempt jurisdiction. but they hold religious, they hold a marriage there, and they put up the board of a religious denomination over there, holding nikahs. And all this is admitted. Now they don't deny this, but they say no, this was only temporary. And I'm sorry, we did not put the board inside the premises. We put the board. Where is the list of judgment? List of judgment. We put the board outside the premises. And your last occasion, your lordship remembers, Mr. Ashok Banerjee, senior advocate.
I'm here, my dear.
I'm so sorry, sir. You were not there in the matter mistake. That we are offering apology, but my lord, apology on a false statement made on oath in reply to a rule is perhaps too late in the day. My lord, your lordships are well aware.
The lady is also there.
Yes.
Millet. I appear for the lady, Millet. She has come, but she's wheelchair bound, so she's outside the court, Millet.
No, these are come.
No. The wheelchair.
Yes.
All containers are even with that lady.
So, my lord, so
respondent number 4.
Record my preliminary submissions. I've shown your lordship the documents also.
Yes.
Your lordship, once I can place the documents again. But on affidavit, they have lied. In affidavit, in response to contempt, they've made false statements on oath. Now, from Mr. Banerjee's submission on the last day, he offered to tender apology. But your lordships have repeatedly held that apology must be tendered at the outset, not when you're caught having committed an act of contempt.
Yes.
Then it is not an act of contrite apology, it's an act of a cowardice.
No, Mr. Banerjee, you had initially denied on oath that you had parted with possession, but it was disclosed from the photographs that you had parted with possession.
Not.
Why shouldn't you be put behind bars at least for a limited period? This is blatant contempt.
Kindly appreciate on us.
This apology is lip service.
No. Apology is genuine apology. Because
but it's a question of apology. You lie on oath, your client lies on oath, Mr. Banerjee. They say they had not parted with possession when they are caught out by the photographs. So where is the question of apology? I mean,
no,
then every contempt will lead to an apology and will be
sorry.
letting you scot-free.
I tried to justify that well. Yes, I was under impression and so many things, my lord. Anyway, it is a mistake on my part. I should admit.
Yes.
And that is why I say, I removed. I could understood. That has not been removed.
Mr. Banerjee, why is the contempt of on a wheelchair? What is her ailment?
But I have filed an application.
You are appearing for.
Obey Lordship has recorded that in Lordship last order.
Yes, what is the nature of her ailment?
Nature of ailment, she can't walk and too much obese. And even 65 and not the age.
65 is not
the age, but so much of
on that we commented on the last occasion, but we are now resisting from doing that because of Leonard Senior Council's objections to that.
No, she's present, Malad, but she's in wheelchair. She's in wheelchair, she's present.
So why is she on a wheelchair? What is the nature of ailment?
She can't walk because of legs. The legs is
what is the nature of the legs means what?
Arthritis.
The others, why shouldn't you put them behind bars? Give us any one reason, Mr. Banerjee.
I'll tell you.
You speak first for the lady, yes?
No, I appear for respondent contender number 2, who is the company. The contender number 3 is Muhammad Irfan, and the contender number 3 is this Khatun, the lady.
Yes, you stated on oath that there was no parting with possession.
No, I'll tell you. The respondent number 3 and 4 are directors of the pro forma defendant. The plaintiff has filed the suit and got the order of injunction. I am the lessee.
It was a status quo order binding all parties.
Binding all parties. So the parting with possession first is the company was the pro forma defendant in the suit. Now 2 of the directors of the company has been implemented as a contemner. So the first thing I'll answer to your lordship, whether the directors, have willfully done anything for lowering the dignity of this honorable court.
Company was not a party.
Company was a party. I'm a director. So
you're in control of the company.
I know, madam. There's a vicarious liability. Whether the
company acts to you.
Company acts to me. But once I'm not in possession. I have given the possession to Kanchon, who is the plaintiff in the suit. Now it is for the Kanchon and the other organization, which is that government Muslim body, which is Mr. Thakkar is complaining of, is in possession. So I have
not a third party that
yes. So I have not given possession. My clients have not given up possession to any third party. We have.
You are not in possession of that property from the inception?
I was in possession. I entered into an agreement with Kanchon, who is the plaintiff. On the strength of it, I have given him the possession. So Kanchon,
that was your plaint case also?
Yes.
You are a plaintiff?
Yes. That's my plaint case. I am a pro forma defendant in the suit. I hold a registered lease deed from the mother landlord.
Your container numbers?
I am 2 is the company, 3 and 4.
3 and 4.
That's the plaint case. So the lessor,
Who are the plaintiffs there?
plaintiff is R1. R1 is the plaintiff.
R1 is the plaintiff.
Mr. Rai is appearing, I believe, for R1, the plaintiff. Now, my lord, R5.
The allegation of violation is against whom? All of them.
All of them. There is no how I and my mother, Ms.
Rai's client obviously got the injunction, the status quo, and therefore they are in possession because they got an injunction regarding status quo.
Client,
Regarding respondent number 1, there is no doubt about
that. Mr. Rai will answer. I only answer for the 3 and 4. 2 is the company. So I filed an affidavit, 3 separate affidavits.
5 is a party to the suit also. Rizaul Khan?
5, no. No, not a party to
whose name was put up as the director of the Muslim organization.
5 and 6 are not parties.
5 and 6, Mr. Thakkar might not have been aware of the order because they are third parties who have been inducted.
Shows the order.
They are not parties to the suit or the appeal.
It quotes the order. 5 quotes the order. The flex, kindly see.
Which page of your content?
Kindly have my petition once, please, Manu.
Yes. Yes.
90.
Volume 7.
Volume 7.
We are now hearing only on this 3 and 4 and 5 and 6.
But yes, your lordship is doing that. But kindly also consider my lord's order of 8 December 20.
Which volume, Mr. Thakkar?
7.
7.
899.
Volume 7.
Page 899, volume 7. Last one. Volume 7.
Rizaul Khan is number 5, 899. And kindly see, my lord, this is signed by Rizaul Khan and Qazi Muhammad Faziullah Ansari, authorized signatories. And your lordship's order is noted there at page 899.
And 900.
The photograph. Kindly see 899, the photograph. Your lordship's order is noted. And these are the contempt numbers.
900 also, 900.
Zoomed out.
Now it's a, I'm sorry, Malad. Kindly see 900 is a better, is a zoom in. Kindly see 900. These are contempt numbers 5 and 6. They are fully aware.
Individuals duly identified and.
First, I'm sorry, Malad. Just below the notice.
Yeah, that we have seen as per the order. Had we directed that?
I'll tell you, lordship.
No, nothing.
Individuals duly. No, let us just complete.
The lordship has not. This is the procedure which they form themselves.
Yes.
But they say in compliance with the above order. Above order permitted ingress egress. Now they form the formalities, but the question is, Malad, were they aware of this order or not? Because even if a third party is not party to the proceeding,
if he's aware, deliberately flouts, yes.
So he's aware, very much aware of the order. These are contempt numbers 5 and 6. And they are the persons, Malad, who held this, solemnized this marriage ceremony. Qazi Fazilullah Ansari, kindly see 901. General Secretary, Muhammad Fazil.
Is their designation is also reflected from the 899, the next board, the board beside.
Nameplate is there.
Yes. In the,
yes.
Yes, page 899 shows that.
General Secretary, the same gentleman.
Yes.
Fully aware. So you can't feign ignorance. And my lord, when Mr. Mitra, sorry to
and regarding the company, they had handed over possession to some third party.
I'll show your lordship the company's affidavit. But before that, since he is saying that I didn't have knowledge, kindly see the first order on which the rule was issued, 8 December 2025. Today, my lord, we see different contemnors speaking in different voices. They are entitled to, but kindly see the order when the rule is issued. Because first affidavits were given, kindly see the appeared for all the contemnors and sought to justify that there is no contempt.
I am never saying that I am not aware.
No,
it appeared for all the contemnors. They were represented to
that the order records.
Appeared for all and sought to justify that there is no act of contempt, rule should not be issued. Your lordship formed a prima facie opinion after hearing them, and then the rule was issued.
Yes, yes.
Now, of course, they have multiple voices, but all say the same. I'll show your lordship from the affidavit. This is contempt, my lord. We have.
No, but Mr. Thakkar, if you don't have positive proof that they were in possession, because the plain case is that
show your lordship
they've handed over
his
possession.
opposition will show.
So show us from somewhere that he was in possession.
No, he says I have not stopped anybody from entering.
Show us that.
Kindly see the affidavit of R3.
Yeah.
Kindly see the affidavit of R3. Kindly see paragraph 5 at page 4 bottom. I am a direct. This is an affidavit of contemnor number 3, Muhammad Irfan Haji.
Director of 2.
who's the director of two MLEs. Anirban Ghosh's backsheet, please.
Yes. Anirban
At
Ghosh.
paragraph 5, your lordship will find his.
No, not that. Slightly thicker one.
This is Madina Khatun.
No.
Anirban Ghosh is.
Khatun adopts, but kindly see the sons. Anirban Ghosh's affidavit.
Both are Anirban Ghosh.
Three affidavits of Anirban Ghosh, my lord. One is the company, and was the son.
And another 3 years. Yes.
But kindly have the companies are short. Kindly see paragraph 5, my lord, just if you're on
Yes.
the same
5,
page.
5, 5.
Paragraph 5 at the bottom of page. I am a director, your lordship has that.
Yes.
Now kindly, he narrates all this. Now kindly come to paragraph 18.
Yes, 18.
Throughout this long period, men and agents of Sudeep Chitlangia, that is the petitioner before your lordship, regularly visit the roof to access the AC plant. Same is operated twice daily. Maintenance of the plant is being done as and when required. Neither R2 nor any of its men and agents have stopped such entry. Men and agents of the purported building association also visit the roof as and when. And
That company is still housed there.
is still housed there. This is just a name lender agreement. And then he says, well, we never stop such entry. Then now he says, I am not in possession. Kindly see, we never stop such entry.
We consented to limited increase and
Yes,
egress.
he's speaking for himself and the lessee, Kanchan Rao. Then kindly see the next paragraph. How does he propose a modus operandi? And I'll show you, lordship, the letter which he writes first. And the false statement on oath, my lord, kindly see paragraph 29, so far as the photograph is concerned. Page 29, your lordship. No problem was faced by him. Kindly see 19. He's again saying there's no contempt.
Page 20.
Now kindly see paragraph 29.
Paragraph.
The letter which he wrote to me that he's in possession.
Page 29.
Volume 7.
In so,
Page or paragraph?
I'm so sorry, my lord, paragraph.
Paragraph 22. Yes.
Now he's dealing with the photographs which show the mobile phone towers.
Yes.
These are the photographs which your lordship has noticed on the last occasion.
Yes.
Now, my lord, kindly see again the false statement here. Kindly now see 31.
Towers are removed subsequently. Towers are still there.
They are very much there. Kindly appoint a special officer to go here and now. Kindly see 31. They are defunct now because they don't allow ingress. Now kindly see 31. It is denied.
The association, by the association means the association of owners.
Yes, association of owners of the. Now kindly see now 31. The last sentence. It is denied that there is any network apparatus or other setup for telecom tower fixed at the suit premises, or that the same is in operation since before passing of the solemn order dated 18 June 2025. A, I am not in possession. B, I show the photograph. Paragraph 31. I'm sorry, my lord. The lordship seen the
Yes.
last sentence of
Denied
it is
that.
denied. The photographs speak for themselves, the emails speak for themselves, and he denies that there's nothing on top.
We are in possession of the
Peaceful possession.
The photographs show the towers also.
Photographs show the towers. They say there are no towers. The email, my lord, the mobile operator is not going to send me email saying that I'm not being allowed access, my tower is shutting down. There specifies the location, which also your lordship has noticed in yesterday's order.
Yes, page 19.
Glaring, my lord.
Page 19, the first sentence.
Yes.
It is an attempt on the part of the association to unlawfully disturb my possession.
Yes. And my lord, his advocate has written this. 902. He says, I'm in continuous peaceful possession. When I'm alleging contempt to his advocate writes, I am in continuous peaceful possession. Now, forget the advocate's letter. This is even better. Unlawfully disturb my possession.
Yes, Mr. Mitra. What do you say to this? My possession?
Mother.
You're lying. I mean, your client is lying like anything.
No, paragraph 19.
This is a blatant lie. Page 19. First sentence, it is an attempt on the part of the association to unlawfully disturb my possession. And you are saying you are not in possession?
This, my lord, is truth. In the affidavit is
still appreciate if your apology was genuine. This is not an apology. You are defending your client.
1995. I hold a registered deed
Whatever you did, forget that.
No, I am in
You are
possession.
admittedly in possession. Therefore, you are guilty. Your first sentence before us was that you are not in possession. You have handed over possession to others, the other containers. And now we find that your affidavit says you are in possession.
It's through
You should have been more
my-
careful, Mr. Mitru. You hold a senior gown now.
But it's through my.
Sorry, it's not personal, but you are an officer of the court.
I'll tell you.
You are of equivalent rank as the judges. We rely on you as much as ourselves.
But why
Sorry,
I say this?
very unfortunate state of affairs.
May I explain this one?
Well, paragraph
May I
34.
explain paragraph 9?
Well, may I just, since your lordship is seeing this, kindly see paragraph 34 also once.
So far,
Kindly see paragraph.
Repeatedly.
Well, kindly no, man, this is blatant falsehood. Kindly see, they're all one and the same. Kindly see 34 now. I say that, your lordship has a third line. I say that respondent number 5,
My
Rezaul Khan,
staff.
he is not associate. He is my staff or authorized person. Now, my lord, kindly say paragraph 3 of Rezaul Khan. Kindly see paragraph 3 of Rezaul Khan. Kindly see paragraph 3 of Rezaul Khan. Now, who is lying? Either Rezaul is lying or the company is lying. Kindly see paragraph 3 of Rezaul Khan. Saulini Bose. Backsheet.
Plaintiff is writing Rezaul is my staff.
Yes.
I respectfully state, kindly see paragraph 3. I respectfully state that I'm a staff member working on.
Roman 3.
3. Paragraph 3. At the bottom of page 2.
Saulini,
Saulini, there might be more, man.
Yes.
Rezaul Khan, kindly.
I am a staff member working under alleged container. Staff member
of Kanchan Jyoti Rao, and he's saying he's my staff member. They've gone overboard trying to defend each other. Paragraph 34 of the company of Mr. Mitro's client. I state that he is my staff member. Mohammad Rezaul Khan is my staff member and an authorized person. And Rezaul Khan says, I am working under contemner number 1, Kanchan Jyoti.
What is the name of this company? The
M&A Leasing, my lord.
M&A Leasing.
Now, the director of M&A Leasing tries to protect Rezaul Khan by saying he's.
No, Kanchan Jyoti Rao is the director of this company. The other company.
Set up, sublessee. Company is the sublessee. Sublessee under MA.
Right.
So, my lord, Rezaul Khan says, I am working with Kanchan. Mr. Mitro's client says, no, Rezaul Khan is working with me. This is a can of worms which is there, my lord. In affidavit in reply to content, my lord, it is. Then he says, Fazlul Ansari also works with me. Mr. Mitra's client in paragraph 34 says, Fazlul Ansari and is in the suit premises since prior to passing of the order. He's very much there. He puts up the board saying, I am the Muslim organized. I'm sorry, the religious organized.
Where is that?
Same paragraph 34. Of Mr. Mitra's affidavit, Irfan Ansari, contempt number 3, which your lordship is seeing. Fazlul Ansari ka dikhao affidavit. Fazlul Ansari. Can you see? Fazlul Ansari is R6.
And what does Fazlul say? Let us see that.
Your lordship has seen, he says prior to passing of the order. So he is saying, the company is saying that Fazlul Ansari is not a new inductee. He has always been there as my employee. Kindly see paragraph 34 once, please, my lord. Fazlu Ansari also works with me and is in the suit premises since prior to passing of the order dated so and so. So he's not a new inductee. And now kindly see what Fazlu says. Paragraph 6 of Fazlul Ansari's page 3.
Associated with alleged container.
I also work with alleged container number 1 as well as under his instructions. So 1 and 3 are one and the same.
7.
I had requested contemner number 1 and husband to use the suit property for short duration for conducting a religious ceremony. I have conducted the ceremony. Now, Mr. Mitra's client says he's my employee. He's been there forever. And you also note Fazlul's paragraph 5. I do not carry on any commercial activity, business enterprise. I only do religious ceremonies. And one is a private limited company.
2 is.
899 देखो 899 देखो line. Now, my lord, in compliance of your lordship's order, purported compliance of your lordship's order, neither Kanchan Jyoti puts up that notice as to how ingress egress is to be done. The two gentlemen who put up are 5 and 6, not the lessee of the premises, not the plaintiff who has obtained this order of status quo.
3 and 4 are the directors of ML leasing, right?
Yes. And 3 and 4 say that number 5 is my employee. Number 5 says I am number 1's employee. He also says number 6 is my employee. Number 6 says no, I am associated with respondent number 1.
Who are the original plaintiffs?
Oh, respondent number 1 only.
Only one.
Only. So technically, Mr. Mitro now would have your lordship believe that he is not in possession. R1 is in possession, but on his own showing, on his affidavit, R5 and R6 are his people, and R5 and R6 have put up that 907 compliance of.
You are ML leasing and 3 and 4.
Yes.
4 and 5. 3 and 4.
And the photograph which your lordship saw, director, they were all put up by 5 and 6. He says 5 and 6 are my employees on affidavit. They're all one and the same, man.
Yes.
Yeah, those are my answers. Right? This I have just handed over to your lordship one page which has relevant paragraphs of 3 judgments, my lord, of the Supreme Court. Your lordships are well aware.
Yes.
The lordships have repeatedly held that contrition has to be at the first. I am not taking a lordship going through the paragraphs. My lords will only consider the paragraphs. Apology is not.
They give the citations for them.
I have given him, my lord. Apology is an act of cowardice is not to be accepted as the last stage, and sentence should be imposed to uphold the dignity and majesty of law. When a false affidavit is filed, of course, it's a case of aggravated contempt. The lordship is seeing Godavarman.
Yeah, no,
lordship is seeing
UP resident employees.
UP resident. Kindly see paragraph 6. In this case, a false affidavit was filed. It is thus clear that Mr. So-and-so has filed an affidavit containing a false statement with a view to give a false picture to the.
6. No.
That is 6, my lord, UP. Second page of the report. Second page of the report, my lord, paragraph 6 of UP.
Yeah. UP resident employees versus New Okla.
Yes. Can you see paragraph 6? That is what is stated in my chart also. Chart become.
Para 6.
Yes. It is thus clear that Mr. So-and-so has filed an affidavit containing a false statement. Then kindly see paragraph 7. It has been held in Hiralal that filing of a false affidavit amounts to contempt of court. By making a false statement on oath, has committed contempt. Then kindly see 9. It is submitted that apology has already been tendered and apology should be accepted. It is submitted that in any event a fine would be sufficient. In our view, the apology tendered in this case is worthless. It is tendered after it was found that the false statement was made on oath. On this own, Mr. So-and-so did not point out to this court that a wrong statement has been made in that affidavit. The affidavit which was to be filed was to state the correct position, etc. Yet he chose to make a false statement on oath in order to support Noida authorities that no plot was available. And then paragraph 11, in that case, the court accepted the apology was sincere and it was tendered to ward off punishment. The court accepted the apology as evidence of real contrite, as also of his consciousness of the wrong done by him. We are not satisfied that the apology tendered in this case is genuine or bona fide. We do not see any reason for accepting such an apology. We therefore sentence him to a period of 1 week under section 12. So apology has to be a
Presidency. Yes. Presidency Correctional Institute. Yes, and the other judgments you have also cited similar.
Your Lordship has Chandra Shashi, paragraph 15. Your Lordship, kindly see
the copies of the other judgments.
We have given, Malad. They are all.
Oh, yeah,
together. They are all together. I'm so sorry. Right. Your Lordship can remove that, Malad.
Chandra Shashi, yes. Chandra Shashi, which paragraph?
Paragraph 15, my lord. Before applying our mind on the question of sentence, we would advert to an offer of unconditional apology tendered by Anil Kumar in his affidavit. This is coming up in appeal, my lord. Kindly see 16. Had the contemner shown real contriteness and regret for the act done, we would have perhaps accepted his apology. But as it cannot be used as a weapon of defense to get purged of the guilt, which precisely the contemner has sought to do, as he desires to avoid worldly suffering which would follow if sentence, we reject his offer and proceed to decide the question of sentence. What sentence, whether fine or in our view, such a sentence would not be conducive to the larger cause of maintenance of purity in the portals of court, inasmuch as if a fabricated document with oblique motive can be filed in the apex court, a serious view has to be saying increasing, then can you see 17, and then we would have longer sentence, etc. But I'm not on that. So apology has to be tendered, unconditional apology at the first instance, my lord, not after a false affidavit is filed and you're seeking to
31 to 35.
And in Godavaram, Godavaram sums up this, my lord. It is a larger bench judgment. Can you see 31? The last but one page of that report. Paragraph 30, your lordship sees. I'm sorry, 28 onward. The explanations of the contemners are clearly unacceptable. Mens rea is writ large. The inevitable conclusion is both the contemners have deliberately flouted the orders of the court in a brazen manner.
Yes.
It cannot be said in it that there was no mens rea involved. The fact situation shows. Learned counsel appearing for the contemners, they have turned it unconditional equality.
Yes, Mr. Thakur, we have seen it. Yes.
Please,
Let us say. Yes, Mr. Mitra, anything else? You cut short your arguments. We won't hear you for long because we have heard you on the last occasion. Make it short.
Lordship will kindly see the order which was passed by your lordship.
Please complete quickly.
The order which is passed by your lordship, Malad,
yes,
which is at page 8, the ordering portion is the 897. The 897, the ordering portion, Malad, it records insofar as the nature.
This is the internal page. Which internal page?
This is 897 volume 7.
Internal page. Internal page.
In 9.
Internal page 9.
Yes.
9. Insofar as the change of nature and character of the suit premises is concerned, however, the subject property ought to be maintained in status quo during the pendency of the list, and as such, we do not intend to interfere with the said portion of the impugned order. Accordingly, FMT is disposed of by modifying the impugned order to the limited extent that the party shall maintain status with regard to the nature, character, and possession of the suit property, with a rider that the defendant appellant and his men and agents might have limited and temporary ingress egress in the suit property for specific purpose. It is made clear that ingress egress shall not disturb the exclusive possession of the plaintiff in a suit property and shall not create inequity.
Yes. What do you want to say on this?
So here the defendants had a limited access to the roof for a specific purpose. Now after this order, Malad, a letter was issued by the advocate on record to them.
We are on your contempt, your complicity.
Yes, my advocate
property being used by others.
No, my advocate on record issued the first letter that once you have been allowed to enter for a specific purpose, we maintain a registrar. So you put in a time of entry and exit also for the purpose you're entering into. Because there is a AC plant on the roof.
That was regarding the defendants. They are not in contempt. Third parties have been permitted to hold marriages and set up their...
Yes, that is not by me. Now the acts of contempt.
Your employee says he's your employee.
Now the acts of complaints, the acts of...
His name is on the board.
Now if my employee's name is on the board, what is
that you submit before us even today that you are not in possession. Your affidavit says you are in possession.
No, but today, Malad, Mr. Thakkar has submitted all are the same.
Forget him.
All are the same.
You have submitted today before us, you are not in possession. Your affidavit says you are in possession.
The paragraph 19, the page 19, the first line.
What is your explanation to that?
It's through my lessee. It's through my lessee.
Written there. Does it appear from the paragraph also?
Through my lessee.
Now, if that's your explanation, it's absolutely flimsy.
If it is so
anything else you want to add, please quickly.
Kindly.
We have made up our mind almost.
No,
just make your submissions quickly.
Come to the color pictures.
Yes.
The color pictures which are given.
Seen the color pictures.
Yes. Now this picture records that the first is Muhammad Rezaul Khan and the second is Qazi Faizullah.
We have seen that. Don't repeat what is there. What is your explanation?
No, the explanation is for the convenience of the people of the building.
Oh, great. Fantastic.
That's we record.
Fantastic. You are running some other organization is coming in for the convenience of the building.
No. they have access
Thank
to
you,
the
Mr.
right.
Mitra. You've heard enough. Yes, Mr.
They have access to the top, my lord.
Heard you enough.
Another thing, my lord, with regard to one decision of the Supreme Court, my lord, because my lord,
Cite it quickly.
I'll take 1 minute. 1 minute.
Yes, yes, sir.
When the company is in
Cite the
contempt,
judgments, Mr. Mitra.
the copy.
Give the citation. Yes. Which paragraph, Mr. Mitra?
My lord, paragraph 8. Paragraph 8, my lord. We are dealing with a civil contempt. The Contempt of Courts Act 1971 explains the civil contempt to mean a willful disobedience of a decision of the court. Therefore, what is relevant is the willful disobedience. Knowledge acquaints substantial importance qua the contempt of the order. Maybe because of a subordinate officials acted in disregard to the order of the court, a liability cannot be fastened on the high officials in absence of knowledge. When two possible views are possible, the element of willingness vanishes as it involves the mental element. It is a deliberate, conscious and intentional act. What is required is a proof beyond reasonable doubt, since the proceedings are quasi-criminal in nature. Similarly, when a distinct mechanism is provided that is the same judgment, this is on the judgment itself, my lord. Now, the last 4 lines of the same paragraph. While dealing with a contempt petition, the court is not expected to conduct a roving inquiry and go beyond the very judgment which was alleged violated. The same principle has been applied with more vigor when the disputed questions of facts are involved and they are raised earlier, but consciously not dealt by creating a specific form of the original proceeding.
Yes.
Now, my lord, this also contains in paragraph 10, it records that there is no material on the facts of that case, my lord, that the vicarious liability as a principle cannot be applied in a case of contempt. So far, my lord, my client, which is the lady who is concerned, is a director. But my specific case in the affidavit, in the answer to the rule is that I am a director. The company is a family company run by
Your
my
son
husband.
is also a director.
My son is also a director. So my son is also a director.
Yes.
There's the specific case of respondent, the contender number, that lady, respondent number 4, that I am a director. I don't responsible for the day-to-day affairs of the company. I have not visited the property in question for last many years. And the company is a family-owned company which is run by my husband and my son. So it is not that on my instructions, these incidents have taken place. In any event, I have tendered my apology. So this is so far respondent number 5.
One of the directors of the company.
Yes, I'm one of the directors of the company. So I cite this, the principle of vicarious liability cannot be applied if the company is the party. But I'm a director. But to the extent of my knowledge or to the extent of my willful act of deliberate violation. Because they have made me a party to the proceeding because I'm a director. Only for that, because my name is in the register of companies, I'm a director. Now, to the extent of my involvement is there. So that is the reason why this is one. And the second is, my lord, so far my client, the other director, that will kindly take his affidavit once, which is the container number 3's affidavit.
Yes, son.
Yes, my son's affidavit, my lord. I have specifically said, my lord, well, I'll tell you, lordship, this MA leasing is a lessee under of the roof from 1995. I am in possession. This MA leasing is in control of the roof from 1995. Annex the document. Now, thereafter in 2024, we executed an agreement with the plaintiff, sublease with the plaintiff. Now, the plaintiff has been given possession and the right to use and commercially exploit the roof thereafter. That has been done.
You've said that. Why are you repeating?
Yes, I've said that. So I say that I was all along in possession of the roof. And today, when my lessee has gone into in possession, my lord, these letters were issued because I'm also a party to the suit. I have worked out a modus, my lord, so that they get a limited access to the roof. Now, the next point which is being urged, my lord, with regard to telephone tower. Now, still I say, my lord, there is no tower, the sense we understand. There is no tower.
What is your sense of understanding?
No, there's a long tower, which we see.
What is this?
This is a apparatus, a white box in the parapet wall. Secondly, this is not a tower. This is the parapet wall. There is a small apparatus. Secondly, my lord, there is no letter to me that I am not allowing the Reliance or the Geo operator or the service operator to access. There is no letter here also. There is no letter annexed to the contempt application which says that any access to the the service provider has been stalled. There is a letter between the Reliance and the association, which is annexed. Not a single letter by saying that we have stopped access. Daily, there are air-conditioned plants in the roof, which belongs to the defendant as well as to the other occupants. They go to the roof daily in the morning, and this is the system for last 20 years. It is operated daily twice. Once in the morning is put on, once in the afternoon is put off. Even for other purposes. Lordship, now kindly see the colored photographs. The colored photographs, which are the complaint, is that the access to the tower has not been given. Now, there is not a single letter addressed. If I am answering only for Irfan, which is the contender number 3, or even to the company's behalf, or even my mother's behalf. So, there is not a single letter addressed to me that I have stopped entry of any operator to access to the roof. On the contrary, I have said that this access to the roof is always there. And one letter which is from the operator company, which is now annexed here, with regard to that tower, which is that in volume 7.
We have heard you enough. Let us hear.
Volume 7, one letter.
Not elaborating on this much.
So this letter is not addressed to me.
Yes.
So I say that I have not willfully violated.
Yes, Mr. Rai, who are you appearing for?
1 and 5.
Only 1 minute.
1 and 5.
I'll take
one. What is your stand?
My stand is, your Lordship's order covers it as to who's in possession. So, today coming to court, there might be wrong affidavit, false affidavit, whatever it is. In my stance, I'm in possession. Your Lordship has held that in the violated impugned order, whichever they say. It is there for your Lordships to see. So, I have said I am in possession. No dispute about that. Now, next, I will obviously take the point that, what was the scope of the order? And what are the acts of contempt complaint? Because, your Lordship has made your Lordship's mind more or less clear that I'll be held in contempt. So, I will obviously, try and assist your Lordship also in a manner so that I can catch on to the last straw, So, kindly does not take me amiss, Now, the thing is, when your Lordship is seeing the acts of contempt, kindly appreciates, your Lordship will also have to see that the fundamental basis is there in a Lordship's order. Vis-a-vis the contempt complained of. There is one. Second, I know, it is very technical, but I will hold it to my learned friend's client, Acts of contempt are supposed to be, spelt out. Now, I will try and assist your Lordship that, because, they are very specific now. Because in your Lordship's order, whatever was there, I say I have not violated it because I am still in possession. Now, the question is whether, putting up about the festoon, I've got something else to say. But let me, for the time being, take it that I have put up the festoon. The flex, flex, I think they call it the flex. Let us say I have put it up,
Yes.
Have I done away with my possession is the most important question before your Lordship. So, my learned friends will have to come up and say that, yes, I've done away with my possession. What is possession and what is my possession, your Lordship will have to then find out that your Lordship's order, which protects my possession and my use, whether I was using it in my own personal capacity or not. This is another thing, Next is, I'll take the technical point, that it has not been affirmed also as true to their knowledge. It's not there. Nothing has been done there. And on points of facts, kindly let me try and assist your Lordship as to what they have alleged and whether it is in violation. But kindly takes the order first,
We have seen the order. It was placed before us today. Itself.
I don't, I would.
Which portion are you?
Yes, I will not take your Lordship to the entire order,
Don't.
I won't, here your Lordships have recognized that the defendant was trying to take recourse to an earlier order passed by this honorable court.
The ordering portion says nature and character and possession. Status quo, no. The reasons we won't go into.
No, not that,
Only the operative portion says status quo with regard to nature, character and possession.
Absolutely.
We are saying you have violated possession by giving it over to these people to run some marriages.
May I just make one submission,
Yes.
Your Lordship has passed an order.
Yes.
Your Lordship will also look into it that whether I've done it willfully or deliberately, if your Lordship is holding that.
Yes.
Now, I will also have to see, and your Lordship will also find out that on the basis of what your Lordship has passed this order, what your Lordship has held already. But kindly sees that
portion.
Yes, kindly come straight away, Malad, will kindly start from Malad. I'm taking it straight away, Malad, page 7. Yes. Monday. Yes, yes.
Yes.
So I was also going to pray that, if I cannot finish, man, kindly give it on Monday.
No, please finish this immediately. We'll pass our orders today.
Well, then it would be very difficult.
No, difficult to.
Well, then, Your Lordship, I will make my points, whatever I can,
Yes,
Your Lordship.
do that.
But kindly sees 21.
Yes, 21, we are there.
Hence, the injunction order, read in conjunction with the averments made in the plaint and the reliefs sought therein, make it abundantly clear that the same pertains to respective flats and the office spaces. So, what they were referring to were with respect to an injunction with the flat and office space. Now, my suit, my lord, where I came up before Your Lordship, is to safeguard the lease granted by MA to me.
Yes.
And Your Lordships then find, Your Lordship will then find yes. Now, my lord, 22, Your Lordships holds that it is important to the roof. Then, my lord, kindly sees 24.
Yes.
Since valuable, it's the second sentence. Since valuable rights and vested interests in exclusive portion of the roof had already devolved upon MA, prior to coming into force Rule 117, subsequent transfers by the said MA with regard to its exclusive portion cannot be had to be hit by 117. So there Your Lordship finds that there has been a transfer of possession. Now, then, my lord, then, my lord, 26. Be that as it may, find for several transfer deeds with regard to the roof, the said transfer carved an exception with regard to the ingress and egress and other necessary facilities and benefits with regard to the roof. That apart, in view of the fair concession given by learned counsel for the plaintiff. Now, this was on concession. And the pro forma, MA leasing to the effect that they would not have any objection if ingress and egress is allowed to the defendant in the present suit in respect of the suit property, where the impugned order can be modified. Now, my lord, kindly sees, first in 28, Your Lordships are of the view that there should be a status quo during the pendency of the lease, and we do not intend to interfere. So this was the status quo which the trial court had passed. Your Lordship, it was in my favor. Now, Your Lordship kindly sees, accordingly, it is disposed of, modifying the impugned order to the limited extent, the party shall maintain status quo. And with regard to the nature and character and the possession of suit property, with the rider that a defendant, now, my lord, defendant and appellant and his minor agent might have limited and temporary ingress and egress to suit property for specific purpose, if any. So, my lord, it was, sorry, my lord.
Please continue.
Yes, it was open to me, obviously, my lord, to find out whether they had the right. So they must inform me. My lord, there is nothing before Your Lordship, and no letter to me that you allow me. For that purpose, my lord, this register thing was started. And it was also, my lord, to some extent, also, my lord, they were signing and they were being let inside the property. This is the first point. Next, my lord, kindly sees, my lord, there is nothing here, my lord, which specifies about any of the reasons for which, my lord, they would have to be granted entry. As to this is the reason, that is, it was left to the understanding of the parties whether I think that they had that limited purpose for going up there. And the first thing is, my lord, did they ask me? Did they ask me to give them, my lord, the access? Then kindly sees, my lord, it is made clear that such ingress and egress shall not be of such nature as to disturb the exclusive possession of the plaintiff. That is me. Your Lordship is holding it, that I am in possession. And or shall not create any equipment. That's a different thing altogether. Then, my lord, rest were to be at the final hearing. So today, my lord, Your Lordship holds that I am in possession. How am I in possession, my lord? Your Lordship has seen the papers, finding that there's a lease which has been transferred to me. So I'm in possession. Therefore, now, my lord, to show that I'm not in possession, but I must have dealt with the property. I need to give it to someone. Now, what are my learned friends showing today? They are showing, my lord, but let me straight go to the grounds of contempt they have made of. My lord, kindly takes the CPN, my lord.
Yeah, there, yes.
No, sorry. My lord, will kindly come to paragraph.
Yes. Paragraph.
Paragraph 19, my lord.
Yes. Deliberate Paragraph 19, Mr. Rai?
Yes, my lord.
Which page?
Sorry, my lord.
Page 17.
Page 17.
Yes.
It starts, my lord. My lord, since your lordship, my lord, has scarce time, may I just, my lord, join 2 points together?
Yes.
First is, my lord, I will show, my lord, these grounds which they have shown as content, my lord, are not specifically borne out by your lordship, sir. One. Second is, my lord, they needed to be affirmed properly.
Yes.
The affirmation is submission, my lord, subject to correction. These are required under the rules, my lord, to be affirmed either, my lord, true to one's knowledge or belief and or records which they have to produce.
Yes.
My lord, I don't know subject to correction. My affirmation page shows that this is on submission. Now, my lord,
One to 27 or two to my knowledge.
Wow.
19
Yeah.
It's
Petition.
How long more will you take, Mr. Rai?
My lord, if your lordship grants me, my lord, sometime 20 minutes, 20 to 25 minutes. My lord.
And Mr. Banerjee will take 5 minutes, you say?
Only, not more than that.
5, 20, 20.
Again.
আসার দরকার নেই ক্লোজ করে দেব yes due to the elaborate arguments advanced on behalf of the alleged contemners and due to paucity of time the hearing cannot be concluded today on the contempt application for further hearing let the matter be listed on March 2 2026 at 3:30 p.m. the alleged contemners shall be personally present in the said date and time as well. Yes.
Before the next page. My lord rises, my lord.
For that,
yes, Mr. Chatterjee.
My lord, may I be permitted to mention, my lord, yesterday I was mentioning with regard to the review matters, my lord, item number 21. Can some precedence be given, my lord? My execution.
Mr. Chatterjee, you're seeing we are not sitting idle here.
I understand, my lord.
No precedence for the time.
but respondent number 4.
All the response. Yes. একটু গুছিয়ে রেখে দাও
वापस कैसे चाहिए आप वापस कैसे
এটা না এটা আমার কপিতে থাকবে দুটো কপি গুলিয়ে ফেলো না দুজন জজেরটা
কি তো
এই ফাইলটা একবার পাঠিয়ে দেবেন তো আমার কাছে কন্টেম্পটের ফাইলটা সব সূত্র গুছিয়ে রাখতে হবে কাগজে ইয়েস কলম দেন
One lordship, my lord, my pangs and agony is continuing. Once lordship was kind enough to observe this is a burning example of my lord carelessness and apathy in the month of September. Now, my lord, what happened at a point of time they passed the buck upon the AG. My lord, AG has done everything, my lord. Now, what they have taken a plea. I have done all the form has been filled up duly, certificate, everything. Now they have taken the plea. Once you have taken Lukhir Bhandar at a point of time, thereafter, after attaining 60 years, I am getting some pension and my lord the amount which is allotted for all.
The alleged contemners, Mr.
My lord the health service director. Health service director is the alleged contemner.
We'll call them to personally appear.
Yes, my lord. Yes, my lord. Otherwise, this problem will not be solved, my lord. This is
come and explain.
My lord, I am also hesitating, my lord.
Principal Secretary.
My lord, the
yes, you are not complying. Let us
now, my lord, kindly see.
Let them come and explain.
My
These
lord,
are the
what
Director of Health Service and Special Secretary.
For
we have
what,
given you
my lord,
sufficient
this
rope.
This
no.
is the kindly. This is not the issue, my lord. What the treasury officer.
Have they got the money?
My lord,
Have they got the money? Mr.
certain
Prasad, have they got the money?
Treasury officer, my lord, has
Have they got the money or no?
my lord, as of now, because of non-submission of those documents, the arrear pension is
Whatever
not-
they have submitted, you disburse the money by tomorrow.
my lord,
All the document have submitted pursuant
Then
to the
today, comma, at the time of call, comma, learned counsel for the petitioner submits that the unfortunate plight of the petitioners has not yet ended. Full stop. Next para. Despite submission of yes, hand over what you are handing over.
Yes, my lord, kindly see, my lord.
Despite both of you. Mr. Chakravarti, you are giving something.
My lord, I am submitting my lord, this document.
Kindly
As per
see,
their
my lord.
requisition, we have submitted all the
Treasury
formal
officer
duly filled.
Submission of all relevant documents, comma, the
The form was duly filled.
pensionary benefit to be disbursed to the petitioners have not yet been disbursed.
Kindly
Full of learned counsel for the petitioner hands over the hands over photocopies of the concerned documents which have been submitted, comma, which are kept on record. Full of next para, learned counsel appearing for the alleged contemners also hands over a communication by the contemners, by one of the contemners.
My lord, director
Not
health
even one of the contemners.
My lord, the
My lord,
director health service, my lord,
my lord,
Dr.
the two
Shapon Soren.
contemners.
An additional director.
No, my lord, the special secretary. Special secretary is also one of the content.
Dr. Shapon Soren, director.
Communication, no. Communication by alleged container number 2 to the effect that pursuant to the order of this court, comma, it has been ascertained from the local authority that the treasury officer of the concerned treasury office has requested the petitioner number 1 to submit certain documents, and after submission of the required documents by the family pensioner, comma, the Katwa Treasury Office will disburse the arrear pension and present monthly pension as soon as possible. Full stop. Next para. Among the documents asked for are the pension payment order, comma, pension passbook, comma, no marriage, comma, no service certificate from local authority, comma, 2 copies of photographs, comma, etc. Full next para, we find from the bunch of documents handed over to us that the petitioners have that the petitioner number 1 has already submitted a certificate issued by the West Bengal Scheduled Castes, Scheduled Tribes and other backward classes development and finance corporation to the effect that the petitioner number 1 is the widow of the freedom fighter late Udaya Shankar Mukherjee and is unemployment as on the date of issue of the certificate within bracket February 4th, 2026, comma, that she has no income from any sources and annual income of the family to which she belongs does not exist rupees 60,000 during 2024-2025. Full stop. The relevant annexures thereto also show that sufficient details in that regard has been furnished by the petitioner number 1. What about this other pension payment order and the other?
No, but pension payment order is lying with them. We are also handed over to them.
My lord, this
That is why the AG.
no marriage.
Mr. Prasad, can you give a copy of this which you have handed over today
Yes,
to
yes,
him?
kindly.
Which of the documents are not with?
This is on the 27th February 2026, my lord.
It is a communication to the my lord concerned advocate, my lord, but the documents that
What
is
documents
lacking.
have you given apart from this?
My lord, these are the document, my lord.
These are the
These are
total
the
documents. Photographs you have already with the certificate. You have.
Well, only my lord, they are
10 days
insisting.
time be my lord given.
Apart from this, you have to submit this.
These are the documents to disburse.
No marriage, no service certificate.
As per, my lord, I am a widow. This is certified by the, my lord, the appropriate authority of or the IAS officer has been certified by.
No service certificate. This will suffice.
Lord, sir.
No marriage. We don't know.
So now they are insisting, my lord, to refund that particular amount which I have taken under the Lokir Bhandar. Repeatedly.
No, they are not there.
That is not the my lord content.
This letter I have received on today itself. We are roaming in the barandas of Katwa Treasury Office regularly.
Signature and photo attestation by gazetted officer regarding what? You have asked for that. Item 5.
Signature and photo attested by gazetted officer.
LT of pension nomination form. It's already there. LT.
Yes. LT of pension nomination form, self-declaration regarding non-marriage, no service. 2 revenue stamps. These are the my lord documents.
I am paying you from my pocket for the revenue stamps. Please do it.
Yes, my lord.
Please do it. The court will
mandatorily,
pay.
My lord.
The court will pay.
My lord, mandatorily.
My lord, from my officer, I will pay him.
7
I'm giving
days.
you the revenue stamps.
7
Please
days.
buy the revenue stamps and give the money to her.
My lord, 7 days.
Nonsense.
Okay.
This is utter nonsense. for not giving 2 revenue stamps, you are not disbursing the
My lord,
widow
one of-
pension to this lady.
No, my
Her
lord.
husband died for the freedom struggle.
My lord,
This is utter nonsense, Mr. Prasad.
My lord, it is a family pension.
Does that make any sense?
My lord, 7 days mandatorily, my lord, it should be. Otherwise, my lord.
What other documents she has to give?
My lord,
She will not give the revenue stamps. You
no,
personally
this
furnish
is-
the revenue stamps.
My lord, self-declaration regarding non-marriage, no service. LTA of pension nomination form. It is certified.
Non-marriage. She in her affidavit before this court, she has stated that she is the widow of the.
It is certified by none other than the IAS officer that he is unemployed.
No, it is not stated that you are not married again. 62 years. What marriage will you? Are you agreeable to marry her? She may marry you, Mr. Prasad.
My lord,
Will permit a second marriage. You are married already.
no, my lord,
So then you are eligible. So please marry her. Go and marry her, the 62-year-old lady.
I cannot.
Isn't this utter nonsense? Doesn't it apply to your appeal to your conscience,
Yes,
Mr.
yes,
Prasad?
my lord, I should be, but these are because everything, my lord, I
Not
can.
marriage certificate, a 62-year-old lady, you
My
are
lord,
defaming her.
My lord, candidly, I am submitting, my lord. My lord is taking up the matter for long. Everything is.
However, we find such stand on the part of the alleged container number 1
This
to
is the
be
treasury
fit to be relegated to the trash can. Trash-can. Full stop. This court takes note of the fact that the petitioners have been running from pillar to post since long, and there is no substantial effort on the part of the alleged contemners to waive unnecessary and frivolous technicalities and to ensure that the order of this court is complied with and the freedom fighters pension to which the petitioners are entitled is disbursed to them immediately. Next para, on every occasion when the matter comes up before this court, we find a new defense being taken by the alleged contemners for flouting the order of the court. Next para, despite the specific assurance given to this court that the freedom fighters pension shall be disbursed in favor of the petitioners,
family pension.
family pension shall be disbursed in favor of the petitioners, freedom fighters family হবে, on February 27, 2026, means today.
Today.
That is today, evidently for the purpose of creating a facade of defense in the present matter, a communication has been made by the alleged container 2 to her learned advocate, that is the learned additional government pleader, taking shelter under supposed other documents which were to be furnished by the petitioners. Next para, from the very nature of the documents sought by the alleged contemners, it is evident that those are absolutely frivolous for the purpose of granting the family pension in favor of the writ petitioners, particularly in the teeth of the specific order of this court to disburse such pension to the petitioners. Next para, from the affidavit annexed before this court, we find ample evidence of the identity of the writ petitioners, which has not been denied at any point of time in connection with the contempt application as well. Next para, repeatedly asking a lady of 62 years age, within bracket petitioner number 1, bracket close, to furnish a no marriage and no service certificate, despite she having furnished a certificate from the WBSC ST BCDF corporation with regard to her being unemployed is not understandable by this court. Next para, that apart, the pension payment orders and other particulars are already available from the documents previously furnished by the petitioners with the contemners. Hence, this court does not find any further necessity for the writ petitioners to furnish any other document in order for the alleged for the contemners to disburse the family pension to the petitioners. Next para, hence, the contemners are directed, within an outer limit of a week from date, to positively disburse the entire amount of family pension dues in favor of the petitioners in terms of the directions of this court, without insisting upon any further document to be produced by the petitioners. Full stop. Next para, the matter shall next be listed on March 13, 2026 for passing further orders. Full stop. It is made abundantly clear that in the event the color of the money comprised of the family pension is not seen by the present petitioners by the returnable date, appropriate directions will be issued against the contemners.
They are insisting, my lord, to pay, my lord, the pension or Lokhir Bhandar and other thing, my lord.
We'll see to it. Lokhir Bhandar and
Deeply up.
Saraswati Bhandar will take care of on the next.
Deeply up. I'm grateful.
Next one. Next one. Yes, two.
My lord, it is my application. And only thing, my lord, today I am a bit handicapped. If my lord may kindly take it up next week.
On the prayer of the petitioner, the
Petition. Time, Lord, for the petitioner. Read petitioner, Lord.
You are for whom?
This is my application for modification. The writ petition has been disposed of by your lordship on
the prayer of learned counsel for the petitioner in the modification application. Let the matter stand adjourned till March 6, 2026. Next.
I'm grateful, my lord.
You give your name, ma'am. But don't write petitioner. Right? Either for the writ petitioner, you guide her, Mr.
Writ petitioner.
Otherwise, both will be appearing. Yes.
I'm grateful, my lord.
Three. None appears for the parties at the time of call. As a last chance to the petitioners to move the matter, the same is adjourned till March 6, 2026.
My lord, I beg to appear for the petitioner.
Yes.
My lord, on the
Yes, Mr. Rai.
Opposite party in the review application. Review.
okay. My lord, on the last occasion, there was a remarks from the department that a wakalatnama needs to be filed, and my lord was kind enough to.
You have filed that?
My lord, I have filed the wakalatnama, but in the meantime, just on the last date when my lord was taking up the matter, the review applicant number 3, Kaushiki Mohalanbish, expired. That is the death certificate. My lord, that's why, my lord, the copy of the wakalatnama along with the death certificate I am submitting before your lordship because, my lord, now I need to come up with an order 22 rule 223 application.
Who has died? Out. Who has died? Respondent number 3.
No, review applicant number 3, Kaushiki Mohalanbish.
Counsel for the review applicant submits that the review applicant number 3 has expired in the meantime and seeks some time to take appropriate steps for substitution. So accordingly, such leave is granted. So let the matter be listed next on March 20, 2026. Which have liberty to the petitioners, review applicants to mention the substitution application, as and when filed, for inclusion in the list along with the main review application, upon service of prior copies, advance copies of the same on the learned advocate for the opposite parties in the review application.
My lord, review application has already been served, and one more thing is this Kaushiki Mohalanbish.
Substitution application serve a copy now.
My lord, Kaushiki Mohalanbish does not have any legal layer existing.
Whatever application you have to file an application, give that copy to them.
My lord,
immediately after giving the copy, you just mention them. Next Friday, mention them.
My lord, deeply obliged.
প্রথমেই তো ওটা রাখবে খেলে You said can 3 of 2026.
Yes.
But ওটা ওনাকে দেখাও।
Can 2 was not.
That was probably Mr. Bhattacharya is leading you.
Yes.
Mr. Bhattacharya, just check up this that the CAN 3 was made into CAN 1 and filed in connection with the CPAN. Therefore, that was the confusion. It is now CAN 1 in connection with the CPAN, not CAN 3 anymore. This was at the time of filing, this was done. This is by the department when it was being filed.
We were not informed.
There was a misunderstanding probably regarding that. That's no longer CAN 3, that's CAN 1, that's appearing in the list. So you also, if you have a copy of that CAN 3, then you also have to make the corrections on that. CAN 3 of
Milord, CAN 3, Milord, was
CAN
filed.
3 is not CAN 3. CAN 3 was altered at the time of filing. That has been made into CAN 1 of 2026 in connection with the
It has
CPAN.
to be because Milord,
Whatever, but on the last occasion we had
everyone was
cast
under the
aspersions on our
misconception.
officers that CAN 3 is
Milord,
not
what has
appearing.
happened is today
It was sufficient
we are
that there is a
seeking
CAN
your
3.
lordship's leave to file the affidavit in reply. They have used an affidavit in opposition to whatever CAN 1.
Milord, opposition, Milord, is to the recalling application.
That is the
filed by
opposition. Those are the opposition.
Milord, we have
It will be filed on the next day.
Milord, all
No, ওটা নিতেই হবে। Fine. Yes.
Grateful to you.
Affidavits in opposition filed on behalf. You are for the Punjab.
No, Milord, I am for the insurance company.
Insurance. Affidavits in opposition filed on behalf of the insurance company be kept on record. Full stop. On the
affidavits in reply.
On the prayer of the bank, Punjab National Bank.
Milord, in these affidavits, Milord, I
They have all indicated CAN 3.
CAN 3, Milord.
Milord,
So
we have
again,
to.
so now it will be CAN.
Your lordship's order will suffice. Milord, we don't need to correct.
No, you need to. Then এগুলো ফেরত দিয়ে দাও। ফেরত দিয়ে দাও। You make the corrections. We are giving you leave. Learned counsel appearing for the insurance company seeks to file affidavits in opposition. Their affidavits in opposition, whereas the Punjab National Bank seeks to use the replies thereto. However, it transpires that the application which was initially application for recall and or modification of the order dated December 19, 2025, which was initially intended to be numbered as CAN 3 of 2026 was renumbered as CAN 1 of 2026 in connection with the CPAN 1997 of 2024 and accordingly rectified at the time of filing of the application itself. Push up next para, as such, the leave is granted to the learned advocates on record for the parties to carry out the necessary rectifications in the cause titles of their oppositions and replies. To that effect, full stop, the corrected copies of the affidavits in opposition and reply shall be filed on the returnable date. Full stop. The time for filing the same is extended for such purpose till March 6, 2026, when the matter shall next be listed.
And instead of March 6, keeps it on March 13th.
13.
It's subject to everyone's.
6 na kore 13.
6 minutes, they are in some difficulty.
13.
Milord, we shall be filing it on March 13, Milord.
You shall be filing it on March 13 on the returnable date, and I've granted you leave to rectify the cost side.
Well, only thing I'm indicating, Milord, we shall be circulating it so that Milord, on March 13 there is no adjournment.
Do that.
Milord, let the copy of this reply if there be
Yes,
any.
আমি করে দেব।
Everything. We are not passing any directions.
Yeah, sir, understood. করে দিচ্ছি।
Give you a copy of everything to the state.
Yes.
Yes. Yes.
So Calcutta is the state. Yes.
Great.